Well, good morning. It's now 9:30, and so I'm going to resume the inquiry into the appeal made by Burcot Solar Farm Limited against the decision of South Oxfordshire District Council to refuse planning permission for the installation of a ground-mounted solar photovoltaic array, co-located battery energy storage scheme, together with associated infrastructure, security fencing, CCTV, access gate, and on-site biodiversity net gain at Burcot Farm, Burcot, Abingdon, Oxfordshire, OX 143GW. Can I remind everyone to make sure that their phones and other electronic devices are either on silent or switched off? And I take it because no fire alarm is expected today, so if it goes off, get out. So this is the third day of the inquiry. So far we've heard all the evidence from the council, and we're partway through the appellant's evidence. So we're going to continue with this today before hopefully going on a site visit this afternoon. So before we resume, just housekeeping matters, I did update the conditions last night, just because I was aware that some of them were pre-commencement conditions, and so in theory I need, well, in practice, not just in theory, and I need to make sure the appellant is happy with those. And I'd say just the one that's left is just the sheep grazing, which we pick up when the council have time to look at it and consider what they want to do on that front. Are there any other housekeeping matters? Right, well, I'll invite Charlie if you want to start your examination.
Would you like some documents to get up?
Yes.
So Mr. Cusson's proof and appendices.
Yeah, I've got those.
And the local plan.
That's 5.1.
5.1. And the Bramley High Court decision, which is called document 7.11, I think. The PPG, which is called document 6.2.
Yeah.
And finally, core document 8.1, which is the South Oxfordshire Climate Action Plan.
Yeah.
Okay, I think that should be okay to start with. Mr. Cusson, I'm going to start by introducing you from section 1 of your proof. And you say there you have a BSc in Geography with Economics and a diploma in Town and Regional Planning. And you're a chartered town planner, having been elected over 25 years ago. And you hold the position of Senior Planning Director at Pegasus Group. Is that right?
That's correct, yes.
And you explained you've got considerable experience in advising on planning matters, and you set out your professional declaration there at paragraph 1.4, and that still stands.
It does, yes.
And I'm going to, following the inspector's indication at the start of this process, take your proof as read. There's a lot of detail in there about the appellant's case on all different limbs, and instead address some discrete matters this morning with you.
Yep.
And the first thing I want to pick up is some of the points that local residents made on the first day of the inquiry. So one concern that was raised related to potential flood risk, and in particular, we had a local resident come and say there had been flooding, I think about a year ago in this area. And I just wanted to understand your view on the documents here that support the appellant on flood risk.
Yes. As you're actually aware, the application was originally supported with documentation addressing flood risk. And then as part of the appeal, we've updated that. So the key documents, I don't know that we need to necessarily pull them out, but CD 1.22 is the flood risk assessment undertaken as part of the original application, and page 12 looks at the runoff both in terms of what may be generated, but also how that will be dealt with in capacity terms. So that page 12 highlights 272.6 square cubic meters of potential runoff, and a storage within the scheme, which is in the form of swales, which would accommodate 288. So that would exceed that runoff level.
So is your understanding that this scheme would increase flood risk or would contain the?
It would contain. It would meet the requirement to keep the runoff to or below the current levels. The application was assessed, and there's a consultation response from the County Council at CD 4.22, page 8, and that confirmed satisfaction from the local authority. I think that's referenced as well in the committee report, which is CD 4.2. Subsequently, there were amendments to the scheme as outlined in the appeal documentation, the changes document, and included in the submissions was a revised flood risk assessment document 3.16, which updated but really shared the same conclusions in terms of potential runoff, and that there would be no impact on third parties is concluded in that document. So as a consequence, there's no objection, as far as I understand it, from the local planning authority. The requirements are satisfied, and we've got a condition 17, which was agreed yesterday in regard to.
And what does condition 17 require? Does that require looking at the whole drainage issue again?
No, it requires the development of the sustainable drainage scheme. It's really the details of the construction details of the drainage scheme in accordance with the principles of the FRA.
Thank you. Anything else you want to say on flood risk, or should we move on to the next issue?
That's fine.
So the next issue is the battery energy storage system, and there's 2 points that was made on the Thursday. One related to potential noise from that. So what's your understanding of the noise implications in this case?
Again, these have been considered by the technical reports on the applications and the appeal. So we have CD 1.25 was the acoustic assessment undertaken in support of the planning application and commented on by the environmental health officer, which is CD 4.21, confirming that assessment was satisfactory. The subsequent appeal document, similarly to the flood risk, we've submitted a revised noise assessment, picking up any changes on the scheme. That was CD 4.21.
Sorry, was that was the?
Sorry, that's
3.15.
3.15.
3.15 the updated
noise report. So in both all of those documents confirm agreement that the noise implications of the development are acceptable, fall within acceptable levels, and similarly there's a condition on noise mitigation, which was just is condition 19, which again is just confirmation that the noise mitigation measures in the noise assessment shall be installed and operational prior to first export of energy, and that still will address the matters.
Thank you very much. The related issue was related to the safety of the battery energy storage system. Again, if you could just talk the inquiry through the relevant documentation and conditions in this regard.
Yes. So again, fire safety. There was a fire safety strategy and document submitted, CD 1.21, with the original planning application. That was assessed by the fire officers, and CD 411 confirms their comments. And there's also a reference to that comment in the committee reports, which is CD 4.2 on page 3. where it's confirmed. Report. We don't. No objection from the fire risk manager in relation to fire risk from the application scheme. The resubmission addressed fire risk as well. In terms of the documentation for that, there was CD 3.17, which is the fire risk statement, and within that, at 421 specifically in relation to one of the issues around any dealing with fire risk is if it were to be dealt with by water. It's unusual actually that in my experience increasingly the batteries schemes that we deal with, paragraph 421 talks about the implications that any runoff of water would be stored within the development itself. So in the event of a fire, a system of automatically cutting off self-activating valves at the outfalls from any of the drainage from the battery storage areas will be closed, isolating the battery storage areas drainage from the wider environment. The water contained by the valves will then be treated and either treated or released or tankered off as necessary and in consultation with the relevant consultant.
And so that document called Doc 3.17 that you're referring to, is that the outline battery safety management plan?
Yes.
Is that right? And is there a condition that would secure a final battery safety management plan as well?
There is condition 26. There's also CD 3.3, which is the plan of the battery storage area, and that identifies the bunded areas which would contain any water, and it also identifies in grey box on the plan the water storage area. So there is water storage capacity within the development if needed, and then it would be retained within the bunds in the event of it being used.
Thank you very much. Is there anything else you want to say on batteries, or should we move on to the next issue?
So if I could just add,
yes.
in terms of those were the three comments from third parties at the inquiry. So I've dealt with other third party comments. There's section 10 of my proof refers to appendix 7, which picks up any comments that have been made on the application.
So you've taken into account all the objections raised, and so your appendix 7.
Yes.
That doesn't, as I understand, go through comment by comment, but it groups comments
Themed, yes,
into themes,
yeah,
and sets out the appellant's response on each of those issues.
Yeah.
And I don't propose to go through all of that now, but it's there for your reference. I think the next issue to consider, and obviously a very important one here, is the development plan. And it appears to be common ground between the parties that the key document here is CD 5.1, which is the South Oxfordshire local plan. Considering that local plan as a whole, what in your view is the most important policy for determining this appeal?
In my view, the policy which is most pertinent to the proposal, which is a proposal for renewable and low carbon energy, is DS9, which specifically deals with such development.
Should we take that policy up just to have a look at what it says? So I think that's on internal page 206.
That's correct, yes.
So what do you say is the relevance of DES9 in this case?
Well, if you look at the reason justification for the policy itself, the intention is to help increase the use of renewable energy. The council will promote the use of energy from renewable and carbon sources, and the policy itself says the council will encourage schemes for renewable and low carbon energy generation, what we are proposing. We've assessed the application against all elements of that policy. It's got 5 arms, and we view that it complies with all aspects of the policy, and I think that is common ground with the council. That a lack of compliance with S9 doesn't form any part of the council's case. It establishes the appropriateness of the development in principle, and as I say, provides strong support, encouraging its nature of development. I think it's also worth noting the bottom within the policy, it cross-refers to the objectives of the plan, and it's contributing towards achieving 5 of the 8 objectives of the development plan, including provision of essential infrastructure, design, community, the natural built environment, and of course climate change, are all important objectives of the plan.
And so what does DES 9, so DES 9 said the council encourages schemes for renewable and low carbon energy generation. You've said that's a supportive approach, and the intention and the reason justification is to get more of such schemes consented. And it sets out criteria. If you meet those, planning applications will be supported. So you would expect the council to support an application that meets those criteria. And what does those criteria say about use of best and most versatile agriculture?
There's no reference in the policy to best and most versatile land.
And why do you think that is?
I think it's because it's not identified within the policy as one of the primary considerations that we've seen. The reference to various appeals, there isn't a prohibition to impact on best and most versatile land. I note as well that the criteria within the policy and the test is that you do not cause significant adverse effect to the elements of the 5 arms policy. And I think it's seen that in a lot of instances the impact of such developments on best and most versatile land are not generally significant adverse.
So if the council had wanted BMV to be a factor that was a primary consideration when you're considering renewable energy development, and on that basis it has included BMV in this list, what would be the test? Would it be you must avoid BMV at all costs, or what are these criteria? What level of harm do these criteria seek to avoid?
But they're seeking to avoid significant adverse harm or effects.
And in your view, in this case, is there a significant adverse harm to the BMV resource?
No, there isn't. But equally, it wouldn't trigger this policy anyway because it's not in this policy.
Not in this policy at all. And I mean, so you could understand if you look at some of these points. So the policy is saying it's supportive of renewable energy if it doesn't significantly adversely affect things like openness of the green belt. And obviously there's a high policy bar for development in the green belt with very special circumstances, high policy bar of land that's designated AO and B. So this policy is still supporting developments in those high policy bar areas. But as you say, the test has to be significantly adverse.
That's right.
To not get the support.
Yes, yeah. And it's probably worth noting as well that the reference was made earlier in the inquiry that it's not the other factors such as BMV don't need to be in here because there are other policies in the plan. But I'd point out that the factors that are in here, which are considered to be the important factors for determination of renewable and low carbon energy, are also covered by other policies in the plan. There's a BMV 1 is the landscape policy, historic environment. I think there's 4 policies within the plan. I mentioned the green belt. This only assesses openness, as the green belt policy clearly is wider than that in terms of demonstrating very special circumstances on all harms and transportation and residential amenities. So this focuses in on the matters that the council and the policy considers important in respect of these applications.
And you mentioned there other policies in the plan that are relevant to the consideration of this scheme. And what does the council say in terms of all those other policies, landscape and heritage in particular? Is there a conflict with any other policy?
There isn't, no.
So then the next policy, is there anything else you want to say on verse 9?
No.
So the next policy that's referenced in the reason for refusal, that I think we should take up is Strat 6. Let's need to find that in the local plan. So I think that's page 40 of the local plan. And obviously it's now common ground with the council that there's no conflict with this policy. And Mr. Cook explained on the first day of the inquiry from his landscape and greenbelt perspective how that common ground had been reached. And he particularly took the inquiry through the potential impact of this scheme on greenbelt purposes and greenbelt openness. I said at the time when Mr. Cook was speaking that there was part of the approach that was left for you as the planner, and that's paragraph 155 of the NPPF, which tells decision makers what to do when a site is within the greenbelt. And given this policy is mentioned in the reason for refusal, I wondered if you could just, at a really high level, explain to the inspector why you and the council have reached common ground that the criteria in 155 of the NPPF are met, such that it's agreed it's no longer inappropriate in the greenbelt and passes this policy.
Yes. So just looking firstly at the policy itself, it's the strategic policy within the plan addressing the greenbelt considerations in respect of protecting the greenbelt from harmful development, which it says in its first paragraph. It follows the principles of the NPPF in terms of identifying what might or might not be deemed inappropriate development, and for inappropriate development requiring that very special circumstances are demonstrated. As you say, it's common ground with the council, though, in regard to the site being in the greenbelt, but with reference to the new glossary, that the site falls into the definition in the glossary of the NPPF for grey belt. But that brings us to 155
of the NPPF.
The NPPF,
yeah.
Yes. I've looked at the detailed analysis of this is set out in section 7 of my proof, which is from paragraph 711, where I talk about implications of development or the implications of 155 in terms of consideration of the principle of the site. 155 is quoted there at 711. Development of homes, commercial and other development in the greenbelt is not inappropriate with regard to the four arms of that paragraph of the framework. In relation to the first, which looks at utilising grey belt, wouldn't fundamentally undermine the purposes, as you say. Mr. Cook considered the purposes yesterday, but I have looked at some of the purposes, or all of the purposes of the plan. In terms of encroachment, it's notable that the site is only 0.3%. I pointed that out in my proof of 712. 0.3% of the green belt within the district. I think it's also relevant to consider the wider green belt. The green belt isn't just within South Oxfordshire. So at CD 5.6, para 220, I think that's the green belt study. That identifies that the total green belt area is some 66,000 hectares, which 57 hectares on the development site constitutes approximately 0.085% of that green belt area. So a very minimal area of the green belt is affected by this proposal. And I conclude that in that regard, and I think that's shared by Mr. Cook's considerations of the purposes, that we wouldn't fundamentally undermine the purposes when taken together of the wider green belt. And so that arm of 155 is accorded with. Looked at subparagraph B, which is the need for development proposed. And again, within my proof, we'll probably come on, or we will definitely come on to the issue of need in my further evidence, but there is a clear and established need for renewable energy development. That's set out in my evidence. Subparagraph C cross-refers to other paragraphs in the development plan, 110 and 115 of the framework, which are related to sustainable transport. And again, you can take it all as read, I think, in terms of what I then said in the proof. But essentially, I've looked back at 110 and 115. The nature of the development is such that it won't generate significant transportation movements, and it's agreed in common ground that transportation implications of the development are satisfactory. So arm C of 155 is met, and then the final element is D, which relates to housing, and obviously it's not relevant to this proposal. So the overall conclusion then is that we meet 155 and is the development not considered an appropriate development within the green belt as a grey belt development, and that's common ground with the council. That's how we come to the position.
And is that how you've come to the position that Strat 6, well, the council's come to the position that Strat 6 is complied with? Because I think in your proof you also said Strat 6 was complied with, but that was when it was considered. That's
correct, and that's because if the development were to be considered inappropriate development, we have considered the very special circumstances which are referred to in Strat 6. So I set out in the remaining part of my proof from paragraph 727, where I say notwithstanding my view on not inappropriate development, we've looked at VSC, and in doing so, you need to consider the harms. So we've considered the harm to openness and harms to the 5 purposes, and overall come to the conclusion in relation to harm within the agreement, were it to be inappropriate development, is set out in my conclusions at 768 and 769, essentially that the harm is limited overall.
Can I just interrupt with
Yes.
a question in this moment? Just because it's on this, in DES 9, there's obviously one of the requirements is about the openness of the green belt. And is it your understanding that because it's been considered not inappropriate, that is all met?
Yes.
Met.
Yeah.
And I referred in opening, I think it's common ground for the council, but I can provide the case to the Lee Valley case.
Yes, yeah. I mean, yeah, I know the Lee Valley case.
Okay.
So yeah, and then once it's not inappropriate, yes, openness doesn't get considered. I just wanted to clarify.
Yeah.
Yes. Yeah.
And that was considered dealt with because of it not being inappropriate.
I mean, but just on that point, even when there's 9, when we did think it was inappropriate in the green belt, your case was that DES 9 was still met in that case.
That's correct.
And
Yes.
why was that?
Because the very special circumstances demonstrated the level of harm.
We talked about earlier that the barrier in DES 9 is a significant adverse effect, and what are Mr. Cook's conclusions? Does he conclude a significant adverse effect on openness?
No, he doesn't.
So the next policy in the plan I'd like to take up is policy DES 7, which is the only remaining policy with which the council alleges a conflict. I have that on page 202. So, I mean, first of all, you've talked about DES 9 and why you consider that to be the most important policy, and you explained that you thought, reading that, the criteria the council are most concerned about renewable energy are listed there within that policy. And so what's your view about the relative importance of DES 7 to assessing this development?
Relative to DES 9, I think it's a subsidiary policy. The primary policy, as I said, is DES 9. But it's still irrelevant. It's a policy of the development plan. It makes reference to new developments and the requirements that the council apply to that in respect of the effective use and provision of natural resources. And it's relevant to consider as a development plan consideration. But I think it's worth noting that our view is that the policy is primarily focused on other forms of development. The development plan sets out a specific consideration for renewable energy, and that's DES 9. So I don't think we don't think we're saying it's irrelevant to this policy, but I think the primary focus of this policy is other built development. And you can see that from the fact that it talks about efficient densities, particularly for residential densities, and it talks about the design considerations, heating, lighting, the making efficient use of water. But a lot of the criteria that are directed to built form.
And it was said yesterday, the appellant's wrong to say, there's only conflict with one arm of this policy, because there's no way all those 8 criteria would be relevant in any given case. But I mean, if this was a housing development, would all 8 criteria potentially be relevant?
Yes.
And so that's what you say about the sort of relative weight or importance to give to this policy compared to DES 9. And what is the overall aim and intention of this policy, reading it as we must do as a whole?
So reading the policies, again, well, the council have given us advice about that in terms of the reason justification. And they're saying at 821, prudent use of natural resources, key elements to delivering sustainable development, contributing to tackling climate change. So those are encouraging applicants to consider how our existing resources can be used effectively and efficiently. So that's the guidance as to how this policy would be interpreted. It's about tackling climate change, and it's about protecting resources, but using default resources effectively and efficiently.
So if we take those intentions of the policy in turn, I mean, first of all, is this a development that tackles climate change and promotes sustainability?
Absolutely, that's the fundamental basis of the application and the proposal.
And you'll have heard, I assume you're talking for the most part there about the renewable energy generation, but you'll have heard also Mr. Field's evidence on soil organic carbon. And so what's your view on the climate change implications in this case of the conversion of arable land to pasture in and of itself?
It has beneficial effects. There's in terms of the improvement of the soil and the carbon effects of that. There are positive benefits.
And would that be the case if, for example, a housing scheme was being developed on BNB land? Would that have a positive climate change impact on the land itself?
No, it wouldn't. It would have detrimental impacts, and that detrimental impacts would be permanent.
And the second, so first you said it's about tackling climate change and sustainability. You then said it was about protecting natural resources. In the present case, what's your view on whether the BMB resource on the site is protected or not?
It is protected by the proposal doesn't result in any loss, permanent loss of the resource. The resource will be returned to agricultural, or it will potentially return to arable use at the end of the process. It will be maintained for agricultural use throughout the development by the shared or dual use of the energy generation and the agricultural use grazing. So it's a co-location in terms of those uses, and as I say, the agricultural use is maintained and not lost.
And I mean, then talking about that co-location point you make, because the third thing you said about the policy is it's about the effective and efficient use of land, and you said that with reference to 8.21. And if we read the introductory bit of the policy and the first indent as well, I mean, what do they say about efficiency and effective use of land?
So, yeah, the opening sentence of the policy make provision for the effective use of the land and resources, and first bullet point, effective use of the land with densities in accordance with the other policies. So, as we've highlighted in terms of benefits, the design and efficiency of the development, the site has been designed in a way to efficiently use the site to maximise the energy resource that will be generated, whilst reducing the site to the minimum size that will effectively do that. As we've seen and come on to see, the site area was reduced from that was originally surveyed and which is available in terms of the land parcel ownership, and the 57 hectares is an efficient use of the wider site.
And on that design, is that bifacial panels that you're talking about?
Yes, yeah.
And you also mentioned, just before we started talking about efficiency specifically, the co-location of agriculture and solar, so two different operations at the same time.
Yeah.
Obviously that's relevant to the question of efficiency, but is there co-location of the solar with any other functions here as well?
Yes, so the co-located, so the BESS facility is a separate facility. We see different applications for standalone solar, standalone BESS, and multiple applications do come forward for them combined, and in this instance we've got the combined effect. So it's an efficient way of developing renewable energy to support they're supportive of each other.
Thank you very much. So the indent of this policy with which the council takes issue is number 7. And obviously that has to be read with this as a whole with the introduction to the policy, and you've taken us already to the supporting text. And so can you just explain to the inquiry what you understand indent 7 to be doing?
Yeah, so indent 7 is the reference to the best and most versatile agricultural land. We've heard from Mr. Field the extent and the nature of the agricultural land involved in this proposal. What indent 7 says is avoiding the development of best and most versatile agricultural land unless it is demonstrated to be the most sustainable choice from reasonable alternatives, by first considering poorer quality land and with preference to that over that of high quality. So my understanding of that is that it seeks to it's looking at avoiding the development unless it's the sustainable choice. It's requiring that reasonable alternatives may be considered, but as part of that sustainable choice.
And so, I mean, what do you consider to to be the reasonable alternatives in making a sustainable choice in the present case?
Well, in terms of the proposal at hand, we've got there's a key factor in that is a grid connection, as recognised in national policy. The importance of having a confirmed grid connection point. The grid connection is one which is available and subject to gaining planning permission. This development would be generating energy within 2 years and utilising that grid connection. That would allow us to swiftly meet the requirement for renewable energy via a confirmed connection point. That connection point isn't available other than for this site. To seek a grid connection, it's not an easy process, and grid connection offers to date are coming through in the late 2030s, potentially 2037. So if this development didn't happen on this site, then the development of renewable energy on another site would have to go and seek another grid connection, which wouldn't meet those what this site can do in terms of the delivery of renewable energy before 2030. So it would be a less sustainable choice. It would be a less sustainable alternative to choose not to develop this site and be required to go elsewhere. Wouldn't be a reasonable alternative. Another alternative is to develop the whole of the site. I mentioned that the whole of the site was available to this development, and it was assessed.
And how big that wider area that was surveyed was? 90 something hectares.
Yes, yeah. It's set out in the application supported by the BMV assessment, which sets out the wider area that we've set, and that identified wider areas of grade 2 land, which are not being proposed. The scheme has been designed to avoid those higher quality areas of land. So a choice has been made. One alternative was to develop more high grade land, and that's not been taken as the alternative.
So, I mean, where it says, unless demonstrated to be the most sustainable choice from reasonable alternatives by first using areas of poorer quality land in preference to that of higher quality. What do you say about the latter part there?
A preference has been made to first use areas of poorer quality within the site.
And you said essentially the choices. So it says demonstrate to be the most sustainable choice from reasonable alternatives. The alternatives are develop this scheme with the grid connection, do nothing, or use the wider site that was available, yes, which would have broadly energy.
Yeah, so three alternatives: wider site, the appeal proposal as it stands, or alternative 3, not develop this site and seek another connection which wouldn't be available until the late 2030s.
So obviously the appellant here has also looked at whether there's poorer quality land in the wider district. Do you consider that the grade 4 areas identified there represent reasonable alternatives that would be sustainable choices in the current context?
No, so the assessment was undertaken to support the application in terms of time. So the Greenbelt policy was pertinent, but also in terms of the other considerations of the overall proposal, and looked at where there might be reasonable alternatives. As I mentioned, the alternatives, if you were to look at any of those, require a different grid connection and a later delivery, which would be a less it would make less a contribution in the immediacy that we can contribute to in terms of the urgent requirement for renewable energy. It would be significantly later. So it would have a less sustainable benefit.
And in terms of the overall policy, all the factors you pointed to about it being about protecting the natural resources, about efficient use of land, contributing to climate change, and making sustainable choices from reasonable alternatives, including using areas of poorer quality land first. I mean, what's your view on whether this scheme meets or conflicts with that policy?
It does. It's avoiding. It's not. There isn't a prohibition on the use of the best and most versatile land, and the use of poorer quality over higher quality is a preference. It's preferred, but it's not mandated.
And that's I think the key sticking point with the council, because the council seem to read those words preference for poorer quality land as importing a sequential test into the policy. You'll have heard the evidence given in that regard by Mr. Reynolds and in fact Mr. Clapp's questioning of Mr. Field yesterday. Do you remember that?
Yes.
So the words there, first using areas of poorer quality land in preference to that of higher quality. I mean, what's your view on whether that's a sequential approach? I think the council said not a sequential test, but a sequential approach. What do you think?
That's right. I would agree it's not a sequential test. We're in agreement with the council on that. I also don't consider it to be a sequential approach. The wording of the policy and that part of the policy is a direct follow-on from the NPPF. It's the same wording. It's the same wording that was considered in Bramley as being not a sequential test, not requiring.
So is this the? Did you mean the PPG? Or
sorry.
Yeah.
Well, the PPG, but also. Footnote 65 as well.
Isn't it? Yeah, footnote. Yeah. Should we go first to footnote 65 of the NPPF?
So footnote 65 is pertinent to paragraph 188 of the NPPF, which deals with footnote 65 first, but I think there's a more general point about 188, which I'll come on to.
Yeah.
But in respect of footnote 65, if it were relevant to a development management policy, decision, it says where significant development of agricultural land is demonstrated as necessary, areas of poorer quality land should be preferred to those of higher quality. That's essentially the same wording as the council have got in their policy.
And if we look at the PPG as well, so that's called your document 6, DD 6.2, I think. And I think the indent Mr. Reynolds has taken the inquiry to is, the paragraph 13. And there's the bit that starts where a proposal involves greenfield land. Do you want that?
Yes.
So what's the wording used in that list of the PPG?
That bullet point, where the proposal involves greenfield land, whether first point of the bullet point, the proposed use of agricultural land has been shown as necessary and poorer quality land has been used in preference to higher quality. So essentially the same wording.
So the NPPF and the PPG have the same wording as DES 7, which is essentially that poorer quality land is to be used in preference to higher quality land.
Yes.
And we have the High Court case of Bramley, which looked specifically at the wording of the PPG and the wording of the NPPF. And we've gone there already. And the court there concluded, and the council accepts this, that neither the PPG nor the NPPF import a sequential approach or consideration, or require any consideration of alternatives at all on this issue, on the basis of that wording. I don't think there's any dispute that that's what the court concluded in that case. So, given the court concluded that in that case, how do you read DES 7, and what do you think is a reasonable way of reading DES 7?
The only reasonable interpretation I can make is that it's the same wording as the court has made a determination on. It can only accord with that determination that it's not a sequential approach and it doesn't require alternatives. And I think it's relevant in that there's no advice from the council that suggests that either. So, as I mentioned, 821 to 823 is the council's written justification for this policy, explaining how it should be interpreted, explaining how the policy works. BMV is not even mentioned in those paragraphs, let alone giving any guidance how to deal with all that, or a requirement that Arm 7 requires a test, a sequential test or a sequential approach to be undertaken. There's no SPD guidance that supports this development plan that states that that is required either. So there's not policy requirement.
And then Mr. Field was asked yesterday a question about whether DES 7 is the local plan's expression of 188 in the NPPF. And you've just noted they've got quite similar wording. But I want to understand your view on 188 of the NPPF and the footnote there. So what do you understand 188 and footnote 65 to be referring to?
188 is in relation to plan making. Clear from the opening part of the first two words, plans should. The framework itself is quite clear where its intentions lie on the advice it's giving of the policy it has. So, and we can take an example from that, from the policy above, 187. Policies, planning policies and decisions should contribute. So it's clear that policy, that element of the NPPF applies both to plan making and development management. 188 says plans should, it doesn't refer at all to development management. What it does refer to, and it says in relation, so the first bit, distinguishing between hierarchic, international, nationally, locally designated sites, not relevant here. We're not on any of those designations. But then the second bit, allocate land with the least environmental or amenity value, where consistent with framework, and that's where the footnote comes in. That's about land allocation. It's not about even designating or designing development management policies. It's purely about how you should allocate land, and that's the reason why I don't think it's relevant in terms of reviewing footnote 65 in respect of this application.
And while we're on national policy and BMV, is it your view, and was it the court's view in Brownlee, that the written ministerial statement imports a sequential test or approach?
No, it's not.
And we can discuss that a bit more in due course. But in light of your conclusions there on national policy and DES 7, so I understand your primary case is that DES 7 doesn't import a sequential approach, sequential test, and you've explained that by reference to what the High Court decided in Brownlee and the wording of the policy. And were DES 7 to import a sequential test or a sequential approach, would that be consistent with the approach set out in national policy?
No, it wouldn't.
And how would that affect the weight you would give to the policy?
It would lessen its weight if it's not in accordance with development plan. I think that's a planning principle. I think it's a principle shared by the council in terms of the evidence that the council have made in respect of DES 9, where the suggestion was if it didn't accord with NPPF, it would be accorded lesser weight.
And in this context of preferring areas of poor quality, you have provided this site selection report as part of the overall picture in this case. The council makes a number of criticisms of that site selection report. I understand you said it was provided in the context of the application where the greenbelt policies were referenced, and I know you give weight to it as a benefit. Given those criticisms are made in this context, is there anything in particular you want to respond to now, or otherwise are you happy with your proof to be taken as read, and Mr. Clapp to go through that with you, as I'm sure he will?
Yes, I think it'd be useful to explain some of the context. I'm sure the actual detail of sites and the council's consideration of sites, I'm not anticipating that will be brushed over today. So, but I won't go there. We've submitted our rebuttal on some of the points I've got. There are other points I can make, but I don't agree with the assessment that's been made on the 5 areas that the council have suggested. There are suitable alternatives. There are technical reasons in terms of matters such as footpaths, the heritage assets, and other aspects that don't affect our sites but affect those sites. And I think those sites in that regard are lesser sites in terms of their overall development opportunity. But as I said, just in terms of context, we do have 3 site selection reports here submitted at the different stages of the applications in relation to this site. So there was the original planning application, which had the PPS site report, site selection statement. The appeal application had its own site selection statement, and then as part of the appeal submission, that we prepared the consolidated site selection report, which really just synthesised the and tried to address some of the council's criticisms in regard to the site selection approach taken. But I think it's useful just to look at the PPS report to explain the approach really taken on site selection and how the development has arisen really, and why we are where we are. And the process is set out in paragraph 4.3 under the methodology of PPS report.
This core I think it wasn't included in the original core document, but it's referenced within them. It's now core document 11.1. I think both parties referred to it in there. It was the site selection report for the first application, and so it wasn't in. We've got it in there.
So yeah, we've got the document. Paragraph 4, well, as I say, methodology set out at section 4. Paragraph 4.3 so talks through the phases by which the development comes to fore. Phase 1, grid capacity, is the stage at which it's identified that there is a potential capacity on the grid, clearly important for the development. Renewable energy, that the energy you generate needs to get on the grid. It has to get in at a point where there's capacity, and that's one of the key considerations. It's one of the factors that the council, that the government are currently grappling with. National Grid has significant issues around capacity, and capacity needs to be taken up where it exists if we are to address the issues around renewable energy and climate change, and that's supported within the government's policy, latest policy, the Clean Power 2030. So there was capacity on the grid, and it was early 2019 that was identified and initiated really the search for sites, and that constituted the next phase of assessing land availability, looking for suitably sized sites within a what might be a reasonable catchment of that grid point or the potential grid capacity. And the 8 kilometres was the area search, which is 8 kilometres, because the route between the site and the grid would be via underground cables laid within the public highway. Then that 8k is a highway route as opposed to a direct as the crow flies.
And on that 8k, I mean, that's one criticism that's made of the site selection report submitted this appeal, that should have looked at a longer distance or should have provided some more viability evidence. I mean, how does the 8 kilometre distance compare to sort of similar radiuses or different radiuses you've looked at in your experience of dealing with other solar farms? Is it?
I describe it as being at the upper end of my experience of other schemes. The 2 kilometres has been accepted. 4 kilometres, I think, was mentioned yesterday. So the different schemes have the issue really is that no one scheme is the same. They all have different characteristics, and it is a case of individual viability and individual practicality. But I think you've got to overcome different constraints for different sites. Then that would arbiter what might or might not be practicable and what might or might not be viable.
And what do you say about whether or not the appellant should have submitted sort of detailed economic viability evidence?
I don't think that's a reasonable expectation in terms of, well, it's not something, as I say, I've got considerable experience of these schemes. We've never submitted viability. I'm not aware of viability assessments being undertaken on other schemes that we've reviewed. There's not, I think we must have in the order of 20 appeals within the core documents. I'm not aware of any of those that address viability.
And what would be the basis for requiring viability evidence? I mean, is there any set methodology or guidance or anything at all about how the council requires an alternative sites assessment to be carried out?
No, there's no guidance.
And do you say there's policy or guidance requiring an alternative sites assessment in the first place at all?
No.
There's no requirement for the SSR and there's no methodology for doing the SSR?
No.
Sorry, I interrupted
yes,
you there. Was there anything else you wanted?
So yeah, I'll just give you the chronology as well. So we've got the phases, the considerations, land availability, analysis for sites, the elements, the factors that were looked at are highlighted there in phase 3, and the grid route and landowner engagement. So letters and the like were sent to landowners during that period from early 2019. By July 2019, the site had been identified and agreement was with the landowner that it would be available, and so a grid application was made, and that was ultimately gave a grid offer that was accepted and agreed in January 2020. But at that stage, then, having got the grid offer, it was then that the more detailed negotiation with landowners took place. The feasibility was fully assessed in terms of what were the constraints and how it could work. And it wasn't until September 2021 that an option agreement. So there was some 20 months or so site assessment, site working out, and then the option entered into with the landowner. So it's a lengthy process and goes back to what I was saying about. So it was lengthy but considered and detailed, and options were considered to deliver the and meet the requirement and address that capacity that was originally identified. And to do it again would bring back that point about you've then got to go back to square one and do all that process, then try and get a grid offer, and then that grid offer probably is on all likely not going to be available until the late 2030s.
And does the council propose here an alternative site that's ready to go with a grid offer as an alternative to this scheme?
No.
So we've sort of diverged a bit from the development plan, but before we move on entirely, I just want to get your take on the development plan as a whole. So you've explained that in your view, there's compliance with DES 7 for the reasons you've just set out in some detail. But taking the hypothetical scenario, obviously it's the council's case that there's conflict with DES 7. And if the inspector were to find a conflict with DES 7, what implications would that have for your overall conclusions on whether there's conflict or compliance with the development plan as a whole?
I think even on the best, the council's case, conflict with DES 7 is only in respect of the one criteria 7, DES 7. There's no suggestion that the development doesn't meet or is relevant to any of the other 6 criteria DES 7. So I think that the any potential lack of compliance that the council are alleging that we don't accept can only be partial non-compliance with DES 7. And that would then only be one policy within the range of policies within the development plan. I've set out in my proof the analysis of policy in my proof at section 9 looks specifically at the policies within the reasons for refusal, other than for policy, which I also consider, which is the NV1, the landscape and countryside policy. That's not a policy that the council identified in their reasons for refusal, but it is one that I think is an important policy. It's unusual in my experience that a scheme of this nature is one where the council are not putting up a reason for refusal in respect of landscape and countryside effects. I think that's runs to the sustainability and acceptability of this proposal. I share the council's view that the proposal meets N7. I've set that in my proof. And that is a significant consideration in respect to this scheme. It meets that environmental policy and landscape and visual is acceptable. Other policies in the plan, also not mentioned in the reason for refusal, are material are listed in the common ground, and I've addressed them in my policy appendix. And overall conclusion.
Appendix 6.
It's appendix 6, yeah. And the overall conclusion in there that I've reached is that all of those policies are also met. So, as a whole, taking the development plan as we should, taking it as a whole, in my view, we meet all of the policies within the plan, including DES 7. The council's view, partial and non-compliance with DES 7. I don't think that outweighs or suggests a non-compliance with the development plan as a whole. My view is we meet the development plan as a whole.
So I think we'd better move on now to the planning balance. So I think following Mr. Reynolds' evidence yesterday, there's quite a lot of common ground here. So there's some things we don't need to spend a huge amount of time on. So, I mean, first, landscape. You'll have heard yesterday the evidence of Mr. Reynolds that the harm there is limited. You also say the harm is limited to landscape. I mean, just very briefly, could you summarise why you say that?
Yes, well, it's within, as you say, it's in Mr. Cook's evidence that the effects on landscape are highly localised and limited. The site in landscape and visual terms is well enclosed. There aren't public rights of way passing through the development site, and any public rights of way are actually quite distant from it. The highways similarly, so they're not, and also residential amenity. There's no objection in terms of residential amenity. So there are also benefits to the landscape in terms of the development proposals that Mr. Cook told us about, the hedgerow gapping up, the new trees to be planted. There's a landscape and environmental management plan identifies all of the proposals in that regard. So lots of good reasons why I think we all conclude that it is acceptable in landscape terms. However, as we've said, I've recorded it within the harms, because at that point I've been limited and localised.
I think it's also agreed common ground that the harm, well, it is agreed common ground that the harm to heritage is limited here.
Yes.
And then you and the council have both carried out heritage balance and found the public benefits outweigh the harms, and understand it's on that basis that there's limited harm in the overall planning balance. Is that right?
Yes, that's correct. I mean, obviously conscious of the framework requirements and give great weight to heritage considerations. But having as part of that, the framework is clear that where less than substantial harm, and in this instance, less than substantial harm at the lower end, is outweighed by the public benefits. We've got very considerable public benefits. Then that is acceptable, and given that acceptability, that's why we recorded limited weight, and that's why I think there's a shared view.
And you've given no negative weight to anything else in your planning balance, and obviously the council gives one other factor negative weight, and that's the BMB impacts. You said the BMB impacts are neutral. Obviously, part of that consideration relates to your conclusions that there's compliance with DES 7, and there's also the written ministerial statement to consider in that regard. And also the question of the actual impact on the BMB resource. So could you just explain a bit more for the inspector why you come to a conclusion of neutral weight?
Yes. So the overriding point on BMB is that it's safeguarded. There's no loss, and there will be continued agricultural use. The proposal is one which would revert or have the potential to revert back to arable. That will be the choice of the landowner at the point at which this development is decommissioned in 40 years' time. And indeed, it's a choice that any agricultural landowner can make at any time, whether you flip between arable or pastoral, or indeed just leave your land fallow. There's no planning constraints on doing so, really. The period of resting the land from arable will result in improved soil condition yesterday, and there's no suggestion of any impact on food security. So overall, I think it's safeguarded. Essentially, the resource would be improved. You mentioned the WMS and any considerations that may raise. My view on that, this is the written ministerial statement from 2015, Mr. Pickles. 2015 is very dated, 10 years old. There's been considerable weight of policy statements, initiatives that the government has brought forward since 2015 in relation to renewable and low carbon energy. I think that was a statement of its time. Mr. Field seemed to share that view yesterday. A ministerial statement from a given minister. We've had further ministerial statements. The more recent one was the Cortino statement, 2014. There's no requirement.
2024, I think.
Sorry, 2024. Yeah. No requirement in that statement for compelling evidence, and there's no requirement for policy compelling evidence. It's not in the NPP. There's a cross-reference in the NPPG. I acknowledge that, but it's a cross-reference in a very dated PPG to a dated WMS.
And what weight comparatively would you give to the 2024 NPPF as compared to the written ministerial statement?
I'd give it greater weight. It's a more recent statement of policy. I'm conscious of the legal decisions in relation to that, but I think within the decision there was horror in terms of, which I think you took Mr. Field to, in terms of the age of the advice within the respective NCPG and NPPF. There's a consideration. So I think it's less away.
And even were compelling evidence to be the right test in this case, you said earlier you don't think that imports a sequential test. What sort of considerations do you think the inspector can take into account when deciding if indeed there is compelling evidence, if that's what's required?
Yeah, I think if it were required, my view is there is very compelling evidence that this development is appropriate. There's no definition in the WMS or compelling evidence I can't see being referenced anywhere else. I don't see why they'd define it anywhere else, but there's no definition anywhere else either of what that compelling evidence should be. So without that definition, we've got to find our own, and I find the urgent need for renewable energy and other benefits we've identified. The other benefits in relation to VSC. VSC is a test of weighing the benefits of development. The heritage balance is weighing benefits. So we've decided in both of those, we've got those benefits that outweigh those policy tests. So that's compelling evidence to me that this is a very beneficial development. So I don't consider that the WMS in requesting or requiring compelling evidence would require evidence of benefits that imposes a bar as high as some of those other clear statutory tests or policy tests.
So I think the final place to go is the benefits. Perhaps we can turn up the planning balance summary table in your proof. I think that's page 68 of your proof. There's a table there. Yep. So following Mr. Reynolds' evidence yesterday, I think there's a fair amount of common ground on these benefits. One area there's not common ground, but you both give a high level of weight, is the overall renewable energy generation. Mr. Reynolds gave that significant weight rather than substantial weight, because he thought the new NPPF reduced the support to renewable energy. What's your take on that, and why do you say substantial?
So yes, the NPPF says significant weight according to renewable energy. That's not a cap, I would say. It doesn't say you shouldn't accord more if you see more. And I think in this instance we do see more, and that's something that's seen commonly in other field decisions as well, that the weight to be given to generation of renewable energy is accepted as being substantial. I don't think I'm, the phrase outlay used yesterday, I don't think I'm an outlier in terms of taking substantial weight. And some of the evidence that's that goes to that is set out in my evidence of section 9, my proof. So from 9.6 through to 9.49, I'm going to propose to read it all, but there are some key points really just worth noting, I think. The situation in terms of the requirement of renewable energy is critical. The original guidance in the Climate Change Act was that we would seek to do at least 80% reduction in greenhouse gas by 2050. That's been brought down, and subsequent acts have brought that target to 2035. And Clean energy strategy, referenced in my document, in my evidence. It's also there's a range of documents in there. The energy white paper talk about the net zero strategy. The situation is critical. We've got to decarbonise by 2035. It's urgent. The National Audit Office described that urgency as a colossal challenge. And decarbonising is in the context of a 40 to 60% potential increase in electricity requirements or generate demand. So not only are we having to generate or switch our current energy requirements to a low carbon, we've got to accommodate increasing requirements as well. So it's not a standing still. The net zero strategy talks about predominantly that change arising from wind and solar, and that it needs to do so at an unprecedented scale and pace. So what this means is that we need a 5-fold increase in solar over 13 years, as stated in the British Energy Security Strategy in 2022. That's core document 8.19. In 2023, the Energy Strategy Plan reaffirmed that 70 gigawatts requirements, maximising the deployment of ground and rooftop solar. Again, stressing the urgency and critical importance of this. 2024, the NPPSs were designated, and that brought in to bear, and I know it is for significant national infrastructure projects. However,
so is this EN1 and EN3?
EN1 and EN3, yeah,
designated at the start of last year.
That's correct, right. Yeah. What they brought in for NSIPs was the critical national priority for renewable energy, which is a remarkable policy in my view. Really, it incorporates where developments have gone through the mitigation hierarchy and there are unmitigated impacts. Those impacts are outweighed by the need for renewable energy, and those impacts stated in there are such impacts as impacts on greenbelt, impacts on heritage assets, and significant heritage assets of that. So a very, very weighty policy, the CNP, and yeah, acknowledge that's national infrastructure. We're not national infrastructure, but we're 0.1 per megawatt below national infrastructure, and I think that runs to the weight that you can give the EN1 and the EN3, which is a great weight. I think there are significant material considerations in respect to this proposal. Clean Power 2030 is the latest government announcement in respect of their proposals. Obviously, we've got a new administration taking a lot more positive approach to renewable energy. See what they're taking wind, they're taking a different approach to previous administration, and so that document, which is a core document within the, I've got the reference for the core document.
I think 8.27.
Identifies that it brings forward the requirements to 2030, and we've got 45 to 47 gigawatts of solar, 23 and 27 gigawatts of battery required, and I've referenced those at 942 and 949 my proof, and I think they are relevant, very relevant considerations. After 949, my proof then turns to progress at 950. So we've got these targets, how are we doing? And I think my overall conclusion on progress is not well enough, really, that we are falling short of achieving those requirements.
Are we on track to meet those goals?
No. And so that brings to bear this is needed. We need to do this before, and this can be delivered by 2028. And will have energy coming out of this development going into the grid. So all of that weight brings other benefit to why I said it's substantial.
So that's the substantial weight you give to renewable energy generation to meet your targets. The second benefit you give weight to is the climate emergency, and you give significant positive weight there. I mean, why do you say that's a different benefit to the renewable energy generation per se?
So climate emergency, there's a national climate emergency been expressed, but the council have said so too. CD 8.1, page 3 is the Oxford climate emergency statement, and the council have also agreed that with me that it's significant weight. I've set it out in my evidence as to why. It's been accepted at Southlands as well, which I've referred to in there. But this is the climate emergency is a different element. It's a policy objective of the council that we are achieving, and it's a national objective too. So I think it bears weight in that regard.
And energy security. Mr. Reynolds yesterday said that he gives significant weight to that as a benefit. So I don't propose to go through that in much detail, but that you've got the evidence set out there in your proof about why that's a weighty consideration. Again, design and best available technology, that's not something the council's given weight to, but you've spoken already today about the efficiency and the bifacial panels. So again, it's not something I propose to rehearse in great detail. You give that, I think, moderate positive weight in your planning balance. And the battery storage, again, there's common ground between you and Mr. Reynolds here. Mr. Reynolds said he agreed that attracts significant positive weight in the balance. Can you just explain why it's common ground, and why is that a separate benefit to the renewable energy generation?
Yes. So as I mentioned, it's not unusual for developments such as this to be co-joined, but it's also not unusual for them to be separate developments. And battery storage does bring a different aspect to it than the solar. It's about storing energy. It's about meeting the need for energy, or having a reserve of energy for times at which the renewable energy generation is lower. So when it's not as windy, it's not as sunny, you've got the battery capacity. So it is a different function. It also meets the renewable energy objective. The NPS in the N1 and the N3 recognise the role of battery and the importance of energy storage. Clean power explains how battery adds to the flexibility of the renewable energy provision. So it is an element of the proposal which stands on its own and will deliver benefits in its own right, and that's why we've recorded it separate.
So the next thing I just want to address briefly is the grid connection, and this is another one where it's agreed it's a benefit, but Mr. Reynolds says limited weight. I think he said you say moderate weight, but I've checked the statement of common ground and your proof says significant positive weight. So why do you say significant positive weight to the grid connection here?
Yeah, that's correct. It is significant. Significant positive weight. As I mentioned, it's an early opportunity. There's a confirmed grid connection, and it's an early opportunity to deliver renewable energy, and that in its own right is something that carries weight. Significant weight that has been recognised in appeal decisions. Got Southlands as an example, which is CD 7.4 C40. I think the reference is paragraph 101. And in terms of the way in which the grid connection works, just to flag appendix 2 of my proof is the explanation of the way in which the grid connection works, and that makes reference to the the lack of grid connections and the issues around grid connectivity and the issue that the government are grappling with.
And how does the Clean Power 2030 action plan and the bringing forward of the targets affect this consideration? Is it relevant to understanding the weight?
It is. There is reference in there, and I think I've referred to it in my proof, but the statement in there that says where capacity exists, development should be brought forward. Effectively, is what it says. I don't know the exact wording.
And why does it say that?
Because the grid opportunities are limited, so you've got to use them where they are.
The next thing we have is a lack of alternative sites. You've given that significant positive weight. Mr. Reynolds, I think, has given it no weight, but obviously that depends on the approach to the site selection report and your conclusions on that. Notwithstanding that, Mr. Reynolds, I think, accepts there's no non-greenbelt sites in the site search area and no brownfields or other sites. He's got the methodology criticisms and he thinks there are other BMP sites. And I think we've understood the differences between you on that, yeah. So I don't propose to go there in any detail. And the next benefit I do want you to explain a little bit more about is biodiversity net gain. Because you've given this significant positive weight, Mr. Reynolds has given it moderate positive weight. Could you just explain to the inquiry why you say that's not the right conclusion?
So biodiversity net gain is obviously a statutory requirement for some applications. It's not for this one. The application was submitted before the deadline or the point at which the statutory requirement came in. So there isn't a requirement for a gain at all on this application. The level of biodiversity net gain is considerably, if there were that statutory requirement, considerably higher than the 10% requirement in the Environment Act. The very virtue that it was brought into the Environment Act, I think, is evidence of the importance of biodiversity net gain. And the council's ecological emergency, which is within CD 8.1, page 3.
So the council declared a climate emergency. You say it's also declared an ecological.
It's also an ecological emergency, and that identifies the ecological issues in part arising from climate change, but the impact on habitats, the impact on species. So there's clear policy direction that biodiversity net gain is a matter, or ecological matters are something that needs to be addressed, and biodiversity net gain does that. So we've also, I keep referring to other appeals. There are other appeals where the extent of biodiversity net gain, not dissimilar to what's being delivered here, have been given the similar significant weight.
So the next one you have is green infrastructure and environmental benefits. I mean, I think that relies on the evidence of Mr. Cook and Mr. Field about the changes to green infrastructure and the soil. So again, it's not one I intend to tread over now, unless there's something you particularly want to say about it, conscious of the timing.
I think that's been covered.
Again, farm diversification, that was covered by Mr. Field yesterday. So the last point I want to touch on then is the economic benefit. So we heard Mr. Reynolds yesterday accepted that his proof had not taken into account business rates because of a misunderstanding of the Act and the definition of local finance considerations. I mean, you've only given it moderate positive weight, so it's not a significant weight you've given it. But why do you give it that moderate positive weight? What are the economic benefits here?
So there is that element that you just mentioned, the financial contribution, but there's also wider benefits. Clean Power at page 20 outlines the business benefits associated with renewable energy, and in terms of the wider jobs and investment. So there are on-site construction jobs. There is I think it was £53 million investment in the development itself. The Clean Power talks about the wider energy industry, to put it that way, in terms of renewable energy. The renewable energy sector is being seen by this government as part of the wider growth strategy, the industrial strategy, and all of that is set out in Clean Power. So I think there is an economic aspect to this development, and they are beneficial, and I think that carries weight.
So final question, I think we're exactly on the hour and a half we said, was if indeed, which is not what you do say, very special circumstances are required to be demonstrated in this case, with the benefits clearly outweighing the harms, what is your overall view on whether there are very special circumstances?
Yeah, there undoubtedly, I think there are. As you say, notwithstanding that it's not required, there are significant benefits and very weighty benefits to this proposal, as we've just set out: substantial load of renewable energy, and the other significant benefits. The harms are limited, and I've set those out, and I think there's a clear weight in the balance in favour of those benefits outweighing the harms, and that would create very special circumstances.
Thank you very much, Mr. Cussom. Those are the questions I have for you for now.
Thanks very much. I reckon we take a break then, and if we come back at 25 past.
Yeah. Mr. Cussom's in isolation.
Yes,
now, yeah.
yes. But feel free to get my cup of coffee or
I wasn't going to, but now I have to.
or something stronger you might want.
Yeah. Yeah.
Thank you.
Oh yeah, I'd love one. Yeah, thank you.
Keith,
I'll come with you.
okay.
If
Can I get you anything, Mr.
Actually, no, I'll have it. Can I just have a white coffee?
Work coffee?
Yeah, thank you. A cup of tea. Great.
Tea,
Thank you.
yeah.
Yeah. Just no sugar, thanks.
No sugar. Yeah.
Yeah, we can't. Yeah. Yeah. So, and then what's the way? I think just again. Everybody knows. Yeah. And so I think when to see it. Yeah, yeah. On the iPhone. Yeah, yeah. Where you put it?
Okay, that's very fair. Thank you. We'll go on to paragraph 188. It's fairly obvious line of questioning. This is about plans. I know it says that. Right.
It is about plans, yeah.
Yeah. Inspectors have found it to apply at the decision-taking stage, haven't they?
Some inspectors have, some inspectors haven't. As you say, different inspectors take different choices.
It's open to the inspector to do the same here, isn't it? To apply it to the decision-taking stage.
The inspector could do that. I think the inspector would be wrong in doing so.
Okay. Insofar as paragraph footnote 65, I mean, you said it was very similar to the local plan policy DES 7. We can come on to how similar it actually is in a moment, but insofar as the inspector did apply 188 or footnote 65, it would be entirely in accordance with the approach adopted in the development plan, wouldn't it? I mean, your evidence was all about how similar they were.
Yeah, well, it works the other way. That the development plan should be in accordance with the NPPF. The NPPF doesn't need to accord with the development plan.
Yeah, well, we can come on to that.
So
we'll certainly come on to that.
You know, the fact that or the point that I was making was that the similarity between the wording shows that the inference from the policy is taken from 65 footnote and the
And deliberately applied to a decision-taking context. And deliberately applied to a decision-taking context in the local plan. Hearing about
that? The policy is a decision-making policy. I think taking that inference from the NPPF again is flawed in that the development plan that 188 refers to his allocations, not development management policy.
Yeah, there's nothing in the NPPF that says that can't apply to the decision-taking stage, is there?
No.
Right. So what is it inconsistent with?
Well, it was the point that I was making in evidence was that the similarity between the two resonates so that the Bramley decision that applies to the NPPF and the requirement to show sequential sites and alternative sites has also got to apply to the council's policy because it's the same wording.
I'm not sure that's right, but we'll come on to that in a second. Make submissions on that as a matter of law if I have to. Right, let's go to the PPG, paragraph 13. We'll go back there. This is this point about non-sequential approach in national policy. Can you turn up the Bramley decision, please?
You have the
CD 711.
yeah, so
Cool. Can you go to I think it's paragraph 169, please.
nearly there. Yeah, no.
And there's a quotation, paragraph 57 from the inspector's decision letter in paragraph 169.
Yes, and that's right.
This is about Bramley. I'm just recalling where we are. not, or Bramley confirming that there's no national policy requiring a sequential approach. There wasn't a sequential approach required in that particular case, etc., etc. You've got, I mean, that's the topic we were talking about.
Yep.
We'll see. This is where the inspector sets out her reading. You see halfway through 57, it says of particular relevance.
I can see that. Yes.
Of particular relevance, LP policy EM8 does not require the demonstration of any sequential approach. Right?
Yeah, can see that.
So, do you accept that in that context it's relevant for the inspector to consider what the local plan policy is?
Yes, and I think that is true of the local plan policy in this instance.
Yeah, definitely.
No, I mean, that is true, that it doesn't require demonstration of a sequential approach.
Oh, I know that's what you said about this DES 7.
Yeah.
That's fine, we'll come on to it in a minute.
There's a commonality across both.
Well, I haven't asked you that question yet.
No, but
It's nice to have your answer in advance.
Good.
But it'll be relevant in due course for us to consider whether DES 7 requires a sequential approach, won't it?
It is relevant.
And it might provide a completely different context. If you agree with me, which you won't, but if you agree with me about what it says, might provide a completely different context to Bramley.
It would be different in that regard, if that were the case.
Yeah. Okay. And there's no challenge so far as you are aware that the incorporation or reference to a local plan policy that imported a sequential approach would be somehow inconsistent with the framework, is there in this case, or in Bramley rather?
I'm not aware of that being said in Bramley, not the legal expert.
Could you just explain what you meant about what was imported into what? Sorry, I wasn't in your question. You said something about.
Yeah, there's no criticism of the suggestion that a local plan policy could go further than national policy in respect of importing a sequential test. There's no criticism of that.
In Bramley, it wasn't a criticism, or Mr. Cousins doesn't.
In Bramley, it's not a criticism.
Oh, right, you're talking about Bramley.
Yeah, I know what he says about it. He says it's inconsistent.
Okay, so.
Sorry, you asked it. Yeah, I think that's what I took as your meaning of the.
Yeah, I'm
question.
sorry. Forgive me if I was unclear. I probably was.
And so no, my understanding was you were asking does Bramley say that you can't have a policy that has a sequential test?
Yeah,
you're asking.
Yeah,
I'm not aware that it does say that, but as I say, I'm not the legal expert on decisions.
I suspect to be a matter for submissions, but yes, thank you. That's very helpful. And if you were allowed to do that, and it did impose a sequential test, failure to comply with that sequential test would be a breach of the policy, and then a failure to comply with paragraph 187, wouldn't it? Because I say, just for clarity, you'd have failed to protect soils in a manner commensurate with their identified quality and development plan. That's how I say it works.
No, I think is my answer to that.
Okay.
And the reason being that the use of the land or of BMD in this instance for this development does not fail to protect the soils. So there's two pronged really. If you were required to demonstrate that there are other sites that have a lesser use of a lesser BMB, that doesn't necessarily mean that you would be impacting the soils less because we're not impacting the soils.
Yeah.
There isn't. Yeah, that's the point. There's not a harm to the soils.
No,
So
I
the
know
soils
that's
are being
very-
protected and enhanced, is what I'm saying.
It's not the question that I asked you. The question I asked you was whether, so hypothetical, if there is a requirement to adopt a sequential approach and it hasn't been followed, 2 leaps I'm asking you to join me on, there would be a failure to comply with the relevant provision of the local plan and with paragraph 187A of the NPPF, wouldn't there?
No, because the requirement in the local plan would be that you had undertaken a sequential approach and found sites of lesser BMV. Is that what you're asking? So that's what you're suggesting your sequential test would be, that you're developing a site that is of a lower quality in agricultural land quality.
Yeah.
You're not necessarily imparting lesser or different harm to the soil itself in terms of the protection and enhancement of the soil. If the soil quality is not being damaged and the soil quality is being enhanced. So you could do both. You could develop a site of lesser BMV and yet do the same impact on the soil quality in the way in which A is looking to protect, because you're not harming it.
There's 2 things we can separate. There's the issue of whether the policy is complied with, which I've asked you to assume is not for the purposes of my question, and a question of how the policies fit together. So 187 says you've got to protect and enhance in a manner commensurate with the development plan, right? And then the development plan says to avoid BMV development altogether unless you demonstrate X, Y, Z things, right? What I'm asking you is that if you haven't done the requirement, adopted the sequential approach, assuming that that's what X, Y, Z means in this context, if you haven't complied with that requirement, whether you necessarily would have failed to protect and enhance soils in a manner commensurate with the development plan, and therefore there's a conflict with both the local plan and the development plan. That's the question I'm asking you to answer.
And I've answered it 3 times now. No is the answer to that question. And the reason that I'm saying no is because the test in the NPPN is not whether you've done a sequential approach. If the policy were, the local plan policy, were that you've done the sequential approach, and even if you've done that, you've passed the test in the local plan, it's not related to protecting and enhancing. It's a different test.
So you don't think avoid the use of BMV land unless as a protection of soil policy?
But
that's what it boils down to?
The effect of avoiding the land does protect the soil quality if your development is a harmful effect on the soil quality. But if it doesn't have a harmful effect on the soil quality, then whether you develop somewhere else or develop there is immaterial, because you're not affecting. You can develop both sites, either site or neither site, and you're still not affecting the soil quality. So you're not in breach of that. The soil quality is protected or enhanced, but it wouldn't be enhanced if you're not developing it. But we are developing it, we're enhancing it. The different aspects of the soil quality.
I'm going to leave that there. We're going to have to go back to Des 7 now, I'm afraid. 202 of the local plan. You there?
Yeah, sorry, yes.
Great.
Sorry.
No, not at all. Okay. I'm looking at sublim. We'll do it from the very start. New development is required to make provision for the effective use of land and protection of natural resources where applicable, including Mr. Field agreed with me yesterday. This is an applicable circumstance. Do you disagree with that?
Yeah, I don't disagree. It's relevant. Yeah.
And then the key subcategory is 7, right?
Yes.
I just want to. I'm going to go through it in clauses and explore the meaning policy if I can. So I'm going to do the first bit. Avoiding the development of best and most versatile agricultural land unless. So stopping there, cut mid-sentence. This is a direction to avoid development on B&B. I know there's a caveat, that's why I've stopped at unless. You'll agree with me, the starting point is to direct decision makers away from using B&B.
The starting point is to direct away unless. So the unless is
I know it is. That's why we're doing it.
that's why I'm agreeing.
I'm not at any stage here trying to be unfair with you.
No,
I'm not asking you not to read the whole policy. I'm asking you to answer the questions that I'm asking, and I'm going through it in relatively close detail because I want to explore what the policy means. So I'm not saying that's a prohibition as a starting point. Will you agree with me? It's a restriction.
Yes. Yeah.
And then the bit after unless tells us when the restriction might be lifted, doesn't it?
It does.
Okay. And it says to avoid B&B development, covered that, unless it is demonstrated to be the most sustainable choice from reasonable alternatives. Okay?
Yes.
So this is the point we've already covered. I'll just do it for completeness here. We've looked at Bramley, no mandatory requirement to consider alternatives there. Here, local plan, requirement to look at alternatives, isn't there?
Yeah, it doesn't specify what those alternatives are.
Right, okay, there's a difference between us as to whether this means sites or just things generally. But I think you say things generally, I say sites, but we can agree there's a requirement, unlike Bramley, to look at alternatives. I put it that generally.
Alternative scenarios.
And the decision maker will then be making a choice between the alternatives that have been presented, right?
Yep.
And you agreed that's a different context to Bramley. I've just got it in my note, a different place.
It also clarifies what criteria is then being applied to those alternatives.
Yes, I know. I'm coming on to that. Yeah.
I'm sure you will come on to that.
Yeah. So next follows unless it's demonstrated, and it starts with by. So you'll accept the next part of this sentence tells us how to demonstrate that the site is the most sustainable choice from reasonable alternatives.
Mm-hmm. Yes.
And the way that the applicant does that is first use areas of poorer quality land in preference to higher quality land. Do you see that?
Yes.
So that approach tells us what we have to do first, doesn't it?
It says, yes, what you have to first look at the preference.
No. Tells us what we have to do first. We first use areas of poorer quality land, doesn't it?
It's in preference.
In preference to that higher quality land.
Yes.
So it tells you what you do first. The first thing to do, deal with all the high quality land, right?
But it says you should use it first in preference to that of higher quality land. If you say you can't use higher quality.
No, but it tells you, it directs you what you have to do first as a priority, primarily, initially, however you want to call it, right? Mm-hmm. Now, if we've got something coming first, that necessarily means there'll be something that comes after it, doesn't it? So we have, don't we? We've got first and then second. It's a fair way to describe it, isn't it? We've got something that's the first thing that should be developed, and then we've got the thing that should be developed second.
No, it's the first preference is
Doesn't say first preference. First use in preference. So it identifies what you've got to do. Number one, over the thing that you do number 2. That's what the policy says, doesn't it?
It says you should prefer the use of poorer quality.
No, it doesn't say that. It doesn't say that. It doesn't say prefer. It says you've got to use something first in preference. It's an important and clear distinction, isn't it? It doesn't say use something in preference. It says you first use something in preference. Right? Yeah. Now, the obvious question follows that is that is clearly a sequence, isn't it?
I don't accept that this is a sequential approach.
I didn't ask you that.
I know, but it's no, I don't. What it's seeking to do here is ask you to is available first. Is there poorer quality, and you should use that. If there is, then as a preference to using higher quality land. So, but I don't accept that that's a sequence or a sequential, and it is exactly the same words as were assessed in Bramley, and that was what Bramley agreed.
We can turn it up if you want. You said it's exactly the word used in Bramley. Do you want to stick with that?
It's the same. Is it?
I mean,
right,
that's what I'm asking.
All right, I'll correct that. It is. The wording is very similar to what's in Bramley.
Well, it's materially different, isn't it? Because we don't have the use of the words by first. This is a legal exercise. It's like interpreting a contract. There's two words that are at least 2 words that aren't in Bramley, aren't in the same place in Bramley, aren't in there at all, and they make a big difference to how you interpret this particular provision, don't they?
The using poorer quality land in preference to that of higher quality is what's in the NPPF, NPPG, and that's what's being asked to do here. And so my view is it's not a sequential approach.
I suppose it's not going to be helpful. The next line of questioning I've got is comparison to the sequential test, which is in the framework. Is that an exercise that we need to go through, or can I just take as read that you disagree, whatever the similarities in between this and the wording of the sequential test in the framework?
I don't think this is a sequential test, so I don't know you.
Yeah, no, okay. Well, it's a matter of law, construction, and I'll make submissions on it. That's fine. Right, okay. Next bit is yeah, the reference in DES 7 is to new development, isn't it? That's what it applies to.
It does, yes.
And when we're interpreting policy, it's fair to consider that the words have been deliberately chosen, right? Yes. I mean, we've got policies that refer to particular kinds of development elsewhere. We accept this development deliberately applies to all new development.
Yeah, I've not suggested this policy doesn't apply to it. I considered it in this real evidence. It's an applicable policy.
Yeah, well, I think you suggested that somehow the weight should be reduced because it was about residential development, but you just agreed with me that it applies to all new development.
I think it's a lesser weight because the inference is that it is primarily identified as residential development, but I have agreed with you, it does include all new development. I don't think that's the main focus of the policy.
Okay. I'm not going to ask you about that. It's fine. You presented the reasonable alternatives. There were 3 of them. One of them was do nothing. Another one was look at the wider site. The third one was seek a different connection. Do you remember that?
Yes, that's not correct.
That's what my note says.
Well,
Is that wrong?
That's not what I was saying. Though there were the 3 options I suggested were do nothing.
Yeah.
Do the appeal scheme, or go elsewhere. Sorry, no, sorry. The third one would be do the wider site.
Do nothing.
Do nothing, as in.
Hang on, let me just write it down because I don't want to write something that's wrong.
So the 3 options I was saying in evidence were that we've got the appeal scheme. That's one option.
How can that be a reasonable alternative to the development? The development itself, that can't be a reasonable alternative. That's what you're applying for.
It's the alternatives being considered. So the alternatives for the developer are clearly doing what you're wanting to do is one of your alternatives.
What you're wanting to do.
Well,
That's
what
an
you're
interesting.
proposing to do.
Okay. I know you want to do it.
What you're proposing to do,
Okay,
is one of your alternatives. The second alternative, which I highlighted, was the wider site.
Yeah.
And the development hasn't been progressed on the wider site because the decision was taken to not progress a higher quality land. And the third alternative is to seek another site elsewhere, which there are none available.
so one of the things that you think is a
And would be less sustainable. So the third alternative would be a less sustainable choice.
one of the reasonable alternatives is to not do anything at all. Is that what you're saying? That's one of the things that you compared. Because you can see how any development, any scheme for renewable energy gets a massive boost if one of the reasonable alternatives is to doing nothing at all, isn't it?
Yeah, that's why. But we're not. That's why it's not. Well, it's an alternative.
It's not a reasonable alternative, is it?
But well, the other sites aren't reasonable alternatives either, because other locations that are being considered are not going to be a reasonable alternative and a sustainable choice.
But
Because
you haven't yet told me that other sites are something that you should consider as a reasonable alternative. At the moment, we've got the appeal scheme, do nothing, develop the wider
well, that's
site.
because what I'm saying is do nothing. It's because do nothing is what's going to happen if you have to go to other sites. We're not going to be able to develop another site in the time frame that we're looking to develop it.
Okay. You've done necessarily a site selection report. I think you've done 3. Remember that? Not you. Your company, I think, has done 1. Is that right?
2.
2. Okay. We've got this PSS, SSS, and then the CESR. All right.
Yeah.
Okay. Right. So you've actually conducted the exercise that we say that you should have done. Whether or not you've done it properly is a point between us. But you've actually purported to adopt a sequential approach, haven't you? I mean, I know you say it's not one of the reasonable alternatives. I've made submissions on that, but you've actually done it. What we say.
We've done a site selection. We've done site selection reports that have shown the methodology and the reason and the consideration of sites that have led us to develop this site.
I mean, one of the things it says, dig it up if you want. Do you recall reading that it's sequential is a phrase used in this report? I can't recall quite where.
This report we're on.
CSR, CD 318. Yeah, one of the places is. Oh yeah, okay. Yeah, that's 3. There's that. 4.1 in the CSR. Just read the first sentence.
Okay.
So,
Does refer to a sequential test for analysis.
despite everything you say despite how you think reasonable alternatives works as a matter of policy construction, which I obviously disagree with, but we don't spend any more time on, you've actually done the thing you say you don't need to do, haven't you? Or you've at least tried to.
Yeah, and as I said, it's not. Yes, we have done that. However,
I think it's
it
the
wasn't
first time
a
that's been
requirement.
confirmed.
Pardon?
The first time that's been confirmed. I think there's been a lot of we don't need to do a sequential approach. We don't need to comply with it.
We don't need to.
Okay.
That's
But
what I'm
if you
saying.
had actually done it,
However, was that yes, we have done one. However, not because we were required to. We did it because it was part of the evidence base that we support to demonstrate the process of how we've arrived at the site of the kill.
so does it actually matter for the purposes of this inquiry whether you are or are not required as a matter of law or policy or whatever to have done one of these sequential approaches if you've actually done one?
Yes, it does, because the council are inferring that they're not happy with the quality or the way in which it's been done, and that we've failed some form of test. And that the point we're making is it's not a test, it's a benefit.
Okay, we'll come back to what precisely this document contains in a moment. Right, so let's just cover off policy. Talk about DES 9. I think I took you to say this is a proposal for renewable energy. So this is the most important policy because it's the renewable energy policy. Is that the thrust of your evidence on that point?
Yes.
Yeah. It's also a scheme on BMV land, isn't it? You know that?
Yes.
I don't think you deny that there's a BMV land policy.
That's correct.
And I think in respect of DES 9, it obviously says that if you meet the criteria within DES 9, that the development will be supported. That doesn't mean that we don't read the rest of the plan, does it?
No.
In fact, if you go to Strat 1, page 24.
Just it's an electric version.
Okay.
So page 24.
Yeah, I think it's 24. Is that not right? It's 24 on the PDF, sorry, 22 in the hard copy.
I think my PDF is out of sync with your.
Oh, really?
Yeah.
I'll use the internal numbering then. Sorry about that.
Right, I've got Strat 1.
Cool. Okay. I just want you to read to yourself the first bit before it gets to the subdivisions. Just read that.
Yeah.
What does it tell us as to how to approach the development plan?
Take it as a whole.
Yeah. Is that novel? Is that new?
Okay.
So the plan-led approach, read both policies and apply them, right?
Yes.
So policy DES 9 doesn't make express reference to BMV land. I certainly agree with you about that. But we don't, as a matter of law, as a matter of the policy itself, the policy document, we don't deal with local plan policies in isolation, do we?
No, we don't.
We know local plan policies can pull in different directions. We read the plan as a whole, read it all together, don't we?
We do this.
We can't extract from the wording of DES 9 alone that solar farms will be acceptable as a matter of local policy, can we?
No, other policies are relevant considerations.
And you'll recall, I don't know if we need to go to it, but Appendix 16 to the development plan, that's a appendix about climate change policy. And will you agree with me that both DES 7 and DES 9 are in there?
Yes, they are in appendix.
So they're both climate change policies, aren't they? Or okay, I don't get that far. They're both policies that relate to climate change.
Yeah, climate change is objective 8 of the development plan. Both policies say this policy contributes towards objective 8.
EN1, EN3 can leave DES 7 for a bit. Both apply to NSIPs. Yes.
Yes.
If you did cross the NSIP threshold, would be a more onerous application process.
It would, yes.
Haven't had to do any of that stuff because you're not quite over the threshold.
That's correct. They're not considered DCO.
But you're about as large as you could possibly be before you cross the threshold.
Yeah.
So you still want to apply the NSIP guidance.
I think it has weight as material consideration, yes.
Yeah. Not arguing with you. They don't apply, but observation I make, inviting you to comment on, it's a bit like having your cake and eating it, isn't it?
No, it's not. It's common ground, it's material consideration, weight that you give it, it's the decision maker. I give it the weight in terms of what the EN and DSs say about the importance to be given to renewable energy and its delivery and its urgency considerations about how it should be delivered or material weight to this decision.
Mm-hmm. Right, you're taken to lots of cases where solar farms have been approved. Mr. Field said yesterday Lullington was an anomaly. Can we go to the appeal decisions in Mr. Reynolds' proof, back of Mr. Reynolds' proof at page 47, please?
Sorry, at page
47 onwards.
Yeah.
Starts with Lullington, but then there's a Greenbelt one that we don't need to talk about, and then we get on to Marlden Farm. Do you see that?
Yeah.
There was a point of connection issue in this case. Do you accept that? Have you read it?
Yeah.
Do you accept Mr. Reynolds' summary at 590? Do you agree that his summary at 590 and then at 591 is reasonable? Is that a fair reflection of the case?
Yeah.
Okay, great. Saves me some time. And let's go over the page to 750. Oh, sorry, the document is the CD number is 750. Page is 48. Just read that to yourself if you can, very quickly. Just scan it. And same question.
I think it's would it not be better to actually refer me to specific parts of the decision rather than just
Right. Let's go 750.
analysis?
You there?
Yes, sorry, yeah.
Paragraph 17.
Yeah. No.
You read it? Yep. Paragraph 38. Yes. So will you agree that Mr. Reynolds' summary is entirely fair reflection of the case?
I'm not particularly challenging Mr. Reynolds has said about this.
751 is the court document 751. This is Valley Farm. You can see how Mr. Reynolds has framed the issue at 596 of his proof. Yeah, he quotes from what the inspector says, paragraph 85, then just read that. So these are cases about solar farms which interfere with B&B land, aren't they? They are. And there are cases in which inspectors dismiss solar development because they're not happy with how they relate to B&B, yes? They are. So my point is that Lullington itself, not some sort of anomaly, is it? There are other inspectors who've done the same thing.
There are also a lot of inspectors.
I know
the answer is yes. There are other ones who've made similar decisions on B&B. There are a significant way more decisions that have been made.
Yes, it's not a football match though, is it? It's not a case of what do inspectors normally decide. All I'm saying is there are cases in which inspectors have decided the case as we want the case to be decided, we being the council. Yes?
Yes.
It's not an unreasonable position somehow, is it?
Yes. I think some of those decisions are ones where there have been other considerations as well, not just solely B&B.
I'm sure there are.
Some of them are. I think the criticism of Lullington was in specific regard to the suggestion that there would be a requirement or a need to go and survey as of alternative sites in terms of determining their B&B value, and I think that's one where that's not a reasonable approach. I think the thing about Lullington,
well, the High Court found it to be a reasonable approach, didn't they?
Okay, yeah. But Lullington was a reasonable approach based on the assessments or the case made at Lullington that the inspector was able to make that decision. However, I'd suggest that actually that was a different circumstance. The LPA were agreed with the appellant that on the WMS, the 2015 WMS, there was no dispute. In this instance, there is a dispute over the weight to be given to the WMS. So different proposals have different considerations. I agree with you. Yes, there are decisions that have gone in favour. In your case, there are decisions, I would say, a lot more that have gone in favour of our case.
In Lullington, the key criticism was that there was a failure to disaggregate the grade 3 land into grade 3A and grade 3B land, right? That was why the inspector was unhappy with things. And that is something that you've also failed to do in this case, isn't it?
Yes, but I don't think that's a reasonable approach.
Okay, but as I say, High Court says it is.
But it wasn't challenged in the actual. There were elements of it which weren't challenged. It was a hearing. It was considered without a disagreement between the authority and the approach that should be taken.
But it could have been challenged in High Court. Could have been said it's irrational. Could have said somehow it's a failure to consider a material consideration. Some sort of policy requires you not to do that. None of those points are taken.
Yeah, agree.
We'll move on. Okay, so all those appeals, in fact, all the decisions that we've referred to so far in the inquiry, do any of them use 100% BMV?
I can't say categorically. The answer to that.
None of those cases that we've just covered, the three I think there were, none of them include 100% BMV, do they?
No.
So in terms of site density relative to those three sites, this particular appeal is the greatest proportional amount of BMV use. Yes. In a context in which justification for BMV use is necessary, yes?
Yeah. And
we agreed yesterday, the greater the loss, the greater the need for justification, didn't we, Mr. Field?
Yes, that was agreed with Mr. Field.
Yeah. So what we need to do fundamentally is look to your justification and see whether it stacks up. Is that fair enough?
Yeah, but you mentioned loss. I think you're inferring that there is a loss for BMV.
I know what your case is on loss.
But that's why I'm clarifying, because you're wording with loss, and there's, in our view, you need to be clear. There is no loss.
Okay. Well, there's some loss, isn't there? We know that. So when you say no loss, it's not right, is it? Well, there is some loss.
There will be a temporary loss of some areas that would be just like the built fabric, but they will be returned as well.
Yeah. Okay. But they're lost for the duration of 40 years, aren't they?
Yes, well, very small portion.
Just want to be careful because you said no loss.
Okay, I accept as a minimal loss.
Yeah. Okay, so let's do the site selection report. Sorry, I cut you off.
Temporary.
Yeah. Site selection 318. Now, if I'm right about my interpretation of DES 7, I hear entirely what you say. You say DES 7 is a policy about. I think it allows you to include.
Sorry, apologies. Did you say 318?
It's 318, but it can also be 319, depending on
sorry,
what day of the week it is.
Sorry, I was.
It's just this.
I thought you were talking about paragraph numbers.
No. This consolidated site report.
Yeah, I've got that.
But
I went to 318. There's only 313 paragraphs.
Oh right, okay. Yeah. Cool. You there?
Yeah,
great. If I'm right about my analysis of DES 7, that it's a sequential, it encourages a sequential approach. I hear entirely what you say about that. You say that reasonable alternatives doesn't necessarily mean identification of sites. Got your case on that. If I'm right that you do need to have a look at some other sites, then this is a document that you're obliged by the local plan to produce.
If you were right and we were required to prepare a report, we'd probably prepare something very similar. But that wasn't what this was done for. It might be different if there was a test, and if that test set out some kind of methodology, we could do that. It might then be different.
Might be different. Right.
Because we may have said, okay, we need to go and even if the development plan didn't set out a brief, we might in pre-application ask the question and got it could have been different.
Well, it's interesting, isn't it? I mean, if I'm right, I accept you say I'm wrong. It's entirely perfectly open to say that. But if I'm right, and there is a requirement to adopt a sequential approach, you say that this document would be different.
No, I said it could be different.
You said it might be different. It's what my note is. Not that it really matters. I'm not going to quibble with you about that. But so you accept then that if I'm right, that this document is not as it should be? Is that?
No, I'm not. I'm just you're giving, scenarios and asking me to speculate on something, and then use a document that's here.
Well, you've been cross-examined before. That's the nature of the beast.
Absolutely. And so my answer is, well, this is the document that we prepared in the context that we didn't think we needed to pass a test. If you're saying that there is a test, well, we might have done something different.
Well, I am saying that.
Yeah.
So, okay. And if I'm right, and the document doesn't show your site to be the most sustainable choice from reasonable alternatives by first using areas of poorer quality land, then you would fall foul of policy DES 7, wouldn't you? Again, it's a hypothetical, if I'm right.
If you were right, but we're not. We haven't identified other sites that are available and we could be developing that would have a lesser impact on B&B.
I know what the outcome you say of the report is. That's not the question I asked. I'm just asking you to agree with me that if you hadn't done what DES 7 requires, or if this document didn't justify that, then you would fall foul of the requirement of the policy, wouldn't you? I think you said yes. I accept it's a hypothetical answer.
It's quite a leap, though, isn't it? Yes. If you wanted to set that leap, that there were a policy that we had to pass and we didn't pass it.
Yeah.
So yeah.
And then, if that had happened, the plan-led approach would be for refusal, wouldn't it?
No.
The DES 7 tells you to avoid the use of B&B land unless, right? You necessarily, in this hypothetical, wouldn't have demonstrated the conditions within the unless. I'm asking you whether the plan-led approach in that circumstance would direct refusal of the application.
It would direct refusal of the application unless there are other material considerations and unless it is taking the development plan as a whole. The development plan as a whole is breached. In my evidence, I've said at the council's best case, if we didn't pass Arm 7 of DES 7, it would be a minor breach of one policy of the whole development plan. And that minor breach, in my view, does not mean that the development plan as a whole is not met.
Okay, that's your planning judgment. It's open to the inspector to effectively decide, as I've just covered, isn't it? That's reasonably open to her. As we discussed earlier, it's the only B&B policy in the plan. Yes.
Yes.
And it's a policy which is expressly restrictive of B&B development. Yes.
It's a policy which encourages to avoid use of B&B.
Well, you agreed it was restrictive earlier.
Yeah.
In that context, I suppose you'd be weighing up DES 7 and DES 9, right? That's basically what we're getting down to, right?
No, you'd be internally weighing DES 7 as well.
Yeah, and the rest of the development plan. But the big ones that would be in tension in that context, if you had breached DES 7, would be DES 7 versus DES 9.
No, because you were considered DES 7 in its own right. And, if you go back to the original, the starting point of DES 7, that I'm not accepting that by breaching Limb 7, you breach the whole policy. You breach a part of it, the policy. So you can take the policy as a whole. We're still, I don't accept that necessarily not hitting 7 breaches the whole policy.
Right. Let's get back to that.
If you want to explain that.
I just want to have it in front of me before I ask you a question about that. Right. New development is required to make provision for effective use and protection of natural resources, including, right, so the things 1 to 8 are things that you have to do to make provision for effective use and protection of natural resources, aren't they? Because they're included, right? Yes?
Yeah.
And if you haven't done one of those, then you're missing out on one of the requirements of policy. There's 7, not all of which will apply in any case.
Yeah.
So it's open to the inspector to find, isn't it, that a breach of the requirement of subsection 7 is a breach of policy. There's 7.
It is. I don't think that's what's happening here. We've got effective use and we are protecting the natural resources in an applicable way.
Okay. So you produce this CSR. I'm going to call it or the report, which I'll probably call it some other things as well. If I'm unclear about what document I'm referring to, please stop me. You say, as a process, as a part of the site selection analysis, this site was selected from some reasonable alternatives.
Yeah.
Okay. Now, Burcot Solar Farms, a private limited company, incorporated on the 23rd of July 2021. Is that right?
I haven't got the detail on the dates, but I'll take your word for it.
It's a matter of public record on Companies House. There's no survey work or comparative exercise completed before this date, that is before the inquiry, is there?
So I've referred in evidence to page 11 of the site selection statement.
Is that the February 2022 document?
It is.
Yeah. Okay. So is that a document completed before this date? That's before the inquiry? The date being the 23rd of July 2021?
Sorry, say that again.
Is it a date before the 23rd of July 2021?
2023.
2021. 23rd of July 2021. Did I say 2023? I hope I haven't, because it's getting close to lunch. Maybe that's it. But look, you can see the point I'm making. Burcot Solar Farm, 23rd of July 2021. That's when it's incorporated. There's no site selection document, no consideration of alternative document that predates the incorporation of that company, is there?
No, because the first site selection statement that we referred to is before it's dated February 2022, was prepared in respect of the planning application. I've explained the process taken in advance of submitting the planning application. It's not a straightforward process. I would add, I agree that the dates aren't at that phasing, that 4.3 that I referred to aren't in the actual document. I put them in evidence. And they predate what you just said. Early 2019 was what I referenced as the start of the grid capacity.
Early 2019. You're looking into the grid capacity then, right? It's not. I mean, it's not in the written case, so
No,
I've got to ask you about
Absolutely.
this. So the early grid capacity. There's no at that stage consideration of alternative sites for this. There's no B&V consideration at that point, is there?
That's the point at which the land availability was sought. It was one of the issues being considered. Soil quality, phase 3 is in there. So in terms of, you've identified there's capacity 2019. How are we going to meet that capacity? We'll find the site. What do? You assess the sites. And that's what the phases in there. And so between early 2019 to making the grid application and the identification of the site in July 2019 was when the assessment of site was undertaken.
Okay, so we've got these three reports: the Pegasus one, two Pegasus ones, and a Public Power Solutions one that come later. But before then, you're asking the inquiry to accept that there's 3 years of surveying, but there's no report generated as a result.
They're reporting the process,
But there's no outcome of any of those processes before this inquiry, is there?
the outcome is the site selection.
But they don't come before the company is incorporated, do they? They come, in fact, much later. I mean, the earliest one is 15 months later, isn't it?
Yeah, because they're prepared to say what has been undertaken to support the planning application at the point at which the planning application is submitted.
Right. Okay. And I mean, it's quite unlikely, isn't it, that you'd incorporate a company without being relatively sure that that company was going to bring forth, in this context, bring forth a development, or at least seek to, right? Okay. So there would have been necessarily quite a lot of work and investment that took place prior to the incorporation of the company, right? And that obviously takes time, doesn't it?
Yes, it is.
What you've told us, I think, is that there was some sort of consideration of alternatives in 2019. I think that's right. Is that what you say? Do you remember Mr. Field said that BMV considerations were taken into account their earliest in May 2020? Do you remember that?
I don't recall that specifically, but that was when it was
No.
turned out I'd accepted. That would presumably be when the actual assessment, the detailed analysis and augering of the site was undertaken. As we've said, such a detailed augering process is not one that you would take at the very outset in assessing sites. I don't think that's a reasonable approach.
All right. Well, you can see what I'm driving at here. I'm asking the inspector to draw a reasonable inference that this company was established before any serious consideration of any alternative.
I think you've just said you wouldn't set up the company without some kind of due diligence. And part of that due diligence is what are the chances of actually achieving what you're setting out to achieve, which would include you address the site.
Well, I'll make submissions on what I make of that. Let's go on. Right. So the correct approach to site selection is informed by national and local policy in this context, right? Yeah.
Sorry, I'm not sure that.
Your approach to the consideration of reasonable alternatives, as expressed in this document, is guided by both national and local policy.
Well, yeah, it's a guidance. There's not a great deal of guidance in local policy on how you undertake it, sort of sectors. So it needs to have reference to local policy.
It needs to have reference to local policy.
Yeah.
All right. Well, let's turn up page 3. The report. No mention of the local plan at all.
Okay.
Page 4.
Yep.
No mention of the local plan at all.
Yep.
That's the end of the policy section, isn't it?
Okay. The policy section, this is one of the supporting documents of the whole planning application. There's detailed consideration of local policy in the planning application.
Yeah, I know.
There's no guidance within local policy. That's what I've made that point. So in some regard, you know, what you would put in here. We could say, well, it looks like plan policy doesn't tell us how to do this. So,
Well, you've set us out a fair amount of national policy, and it doesn't really have any applicability to this exercise either. My criticism is that you've excluded the local plan policy. You've agreed with me that it's been excluded. We can move on.
yeah, okay.
We've got this reference, haven't we, that compelling evidence is not the threshold to be applied. Yes.
Yeah.
Okay. Insofar as that's not correct, document would not have applied the right threshold, right? Is that fair to say?
Sorry.
Insofar as that's incorrect, it's a matter of law, right? Insofar as the compelling evidence threshold is the relevant threshold, this document approaches the wrong threshold because it says compelling evidence isn't the one that we applied.
Sorry, I'm not sure I follow you.
This document proceeds on the basis that compelling evidence is not the right evidentiary threshold to cross for the purposes of justifying this application. Yeah.
Can you point me where that says it?
210.
Yeah.
The written statement makes no mention of a need to provide compelling evidence for the use of best and most versatile land.
Yes, that's correct. That's talking about Cortino 2024.
Okay, so does this document accept then that the 2015 WMS imposes a compelling evidence threshold and that that's the relevant threshold that should be applied? Because if it does, I'm very happy because it's
No, because
a confirmation of what I said.
It doesn't refer to it because it's not referred to.
And of course, let's go to CD 1.26, please.
Right, CD
1.26. You there?
Sorry, yeah, I did it. Oh, I got it. Hard copy actually.
Okay.
Yeah.
Paragraph 4.1.
Yep.
Appellant says confirmed that it was looking across England, Scotland, Wales, identifying sites it considers suitable. Do you see that?
Yes.
I think Mr. Field yesterday said he wasn't conducting a broad search of that kind, or a broad search of that kind hadn't been conducted. Am I right to take what is said in this document, or am I taking what's said in his evidence?
This is the approach of the applicant. It's on this document. I think that's correct. And indeed, so yes, this is that's you know, as it said in that report, this company were looking at opportunities across the country.
So insofar as Mr. Field suggested anything to the contrary, that was wrong.
I don't recall what specifically he said.
So that's why I said insofar as.
Right.
So if he suggested the contrary, that was wrong.
If he suggested that they weren't looking right across the country, then yeah.
Fair to say that benefits of any solar farm, so far as they contribute to renewable energy, will be national benefits. Yeah.
National and local.
There's no need for them to be realised in one particular place for them to be national benefits, is there?
The need for them, no, there isn't a need for them to be realised in one place to be to national benefits. However, they do, in order to be realised, they need to be in a specific place because
They've got
got
it
so
somewhere.
many limited places to go on the grid.
I'm not going to quibble with you about that. They do need to go somewhere for there to be a benefit. That's fine.
They can't go just anywhere, and they need to go. It comes back to the point in clean power. If there is an opportunity, it should be used. There is an opportunity in this locality.
And you've said a couple of times, in fact, there's no methodology and guidance as to how to complete this reasonable alternative consideration exercise in this report. Doesn't mean you can approach this report however you like, does it? The assumptions, the approach that you adopt still have to stack up. They have to make sense. Have to be robust, don't they?
It's to be a reasonable approach.
That's a reasonable approach, and the conclusions that you reach have to be adequately justified. Otherwise, you won't have demonstrated that the site is the most sustainable choice from among reasonable alternatives, assuming my interpretation of the policy is correct.
If the conclusions aren't adequately robustly justified, then you couldn't accept the conclusions.
I've just got one eye on the time.
Yeah.
I've got a fair bit to get through. I wonder whether it might be better to have a very short lunch break and come back, or whether you want to push on. I'm happy just to push on, but it's a entirely matter for you.
Right.
Also, matter for Mr. Custon, who I understand has been giving evidence now for a long period. I don't know if he wants a break. I'm happy for him to have one if he wants one.
What would you prefer, Mr. Custon? Would you prefer just
I'm happy to go on. Well, I prefer to get done today rather than not let them go over tomorrow. I'm conscious you're keen to get to site.
Yeah.
Do you know roughly how much longer you have?
Could be about 45 minutes.
Right. I mean, are you prepared to?
I mean,
You're happy to go on with for that?
I'm happy to go on. I'm happy to do.
Yeah. I mean, look, right, if people are happy to go on, then let's just go on at this stage.
Okay, let's talk about point of connection then. So you quite right, you refer to EN3, you say that applicants can choose a site based on grid export capacity. Reflects the fact that a solar farm will need a point of connection to viably operate, right? Mm-hmm. No sense having sites that can't connect to the grid. Yep, that's reflected in the guidance. Now take as an example a situation in which there are 5 points of connection, 4 of which are surrounded by grade 4 land or lower, and a 5th is surrounded by BMV. If you chose the 5th point of connection, you couldn't say that you demonstrated a need to build on BMV, could you?
That's a significant leap to say that. Let's suppose there are 5 points of connection. There aren't 5 points of connection. The point of connection is a specific point of connection. There's only 1 point of connection available for this development.
For this development, now the site's been determined, yeah. You're not telling me there's only 1 point of connection in any place ever for a solar farm, are you?
No.
No. So it's right, isn't it, that you could take into account the use of BMV before you determine the point of connection, or looking into the point of connection. You could do that, couldn't you?
No, it starts with the point of connection. Because
I'm not asking you whether you have done that. I'm asking you whether you could consider around several points of connection how encumbered those points of connection were by BMV land.
No, that it's a misinterpretation. First consideration on the points of connection is, do they have available capacity?
All right.
And if they do have available capacity, they should be used.
So say there are 5 points of connection done then, all with capacity, right? Are you telling me that you wouldn't consider between them which of them were encumbered by BMV land and which were not? You would just get cracking, whatever was around the point of connection doesn't matter.
Potentially you would. Clearly, you've been needing to apply development plan policy, national policy, to whether you would get planning permission. However, potentially you would build all 5 or seek a site for all 5, because that's what Clean Power tells us. We have a requirement to develop renewable energy, and it should be like opportunities around.
At all costs, is that?
No, I'm not saying, no, I predicated what I said, that you would clearly need to try and get planning permission, and that there are all the planning considerations that come into that. There's also, as you say, not at all costs, because there is going to be a viability point. There's going to be whether that stacks up. So there's lots of considerations, but if all of those considerations lead to you to believe that you could develop all 5, then you should. But you don't start by choosing a site and then hoping it's got a connection.
No. I'm not suggesting you do. What I'm suggesting the exercise you should perform is you identify points of connection that are viable, that are available connection, and then consider which of those points of connection have BMV land around them. That's a consideration that you could reasonably perform, isn't it? It's an exercise you could perform.
Well, it's not a solitary exercise choosing whether it's got BMV. You would, because you start by choosing the site, choosing point of connection.
Start by choosing the site. Is that what you're saying?
No.
I think it ultimately is.
No,
That's
it's
why.
not. No, it's not. You start by choosing the point of connection on the basis of the capacity. I've explained it in here. The starting point, the first phase one was, is there capacity at the point of connection?
In light of time, I'm just going to skip over my other questions on that because I suspect I know who will answer them. Obviously, Greenbelt's one of the constraints that you identified, right?
Yes.
Given the same status as BMV, I think, in the course of this analysis, is that right? BMV is not given any higher status than it.
BMV is not given
No,
any status to Greenbelt. No.
Obviously, we've had the emergence of grey belt policy in the currency of this appeal. Haven't reconsidered your analysis in light of that policy change, have you?
No.
Has the potential to change what you consider to be available land, doesn't it? The emergence of grey belt policy. It's a loss of an encumbrance, isn't it?
It is a change in the policy. I think it's an ever moving feast, isn't it? Policy, and the fact that we have a site that is now policy accordance in local plan in Greenbelt policy works in the favour of the proposal coming forward. Because it's removed one of the encumbrances to this development proposal, and in terms of the timing, as I said earlier, delivering elsewhere in the time is not going to work.
I mean, it's a factor, isn't it, that you've taken into account when you've considered alternative sites.
Yeah.
Some of them get a score because they're Greenbelt, right? A score of a certain level might be a high score.
They all get the same score because it's Greenbelt. They're all Greenbelt.
Right. Okay.
So you're removing the same amount of score from the scoring process. So relatively, they're all going to be the same.
Right, let's talk about cable size. So the original site selection survey, 3.4 of the CSR. Page 7.
What document are we in?
CSR 318 or 319, might be 320 by now. But 3.4.
3.4.
Page 3, paragraph 3.4 in CD 3.18. So the original site survey uses the 8K radius from the point of connection. Yeah,
Yes.
that's on the basis of using an 8K cable. Then we have this business of actually it only goes 5K because to travel, for the cable to travel 5K, it actually has to travel squiggly lines about 8K.
Yeah. Good to
yeah, I don't know. I had to really labour that to myself when I was reading it actually. Okay, so appendix 1.
Yeah, I was going to say, I was going to bring this to the plan because there is a plan that explains that.
Yeah. Shows that to be true, right?
Yes.
You say. That's this plan with all the roads 8K from point of connection.
Yeah.
Right. We can see, can't we, that 8K worth of cable actually gets you quite a lot further than 5K away in a few areas, doesn't it?
Good.
And the report says there are a very limited number of locations where 8K cable route would extend beyond 5K. And I've done the slightly tedious exercise of counting them. And I think I've got either 9 or 10 intrusions past the 5K line. Can you see them? Do you agree with me about that?
Yeah.
So it's clear, isn't it, that 8K cable can extend beyond the 5K radius and at times significantly does so.
That's what's identified on this one.
And what I say about that is that it obviously justifies a wider search basis than 5K that was initially adopted, doesn't it?
But that's what was shown.
So you then say at 3.8 of the report that 8K is the proportionate and realistic search radius. Say that.
Yeah.
So is the radius that's been applied 5K or 8K? I thought we were doing 5. On the basis that within 5K, you need 8K worth of cable.
The assessment, if you look at, the provisional agricultural land classification map, she's got the black dotted line on there.
Which one's that? Which one's going to go to? Oh, yeah.
Well, the search out appendix 5 got the.
That's the one with all the different grades of land on it.
That's correct.
Yeah.
That's got the dotted line, point of connection, 8K. So all those areas are within the 8K. Yeah, search area plan, which is appendix 2. 8K up there in the key.
But what you need, these are within 8K, so won't you need more cable to cover 8K? If you're saying 8K is the search radius, right? And if you have 5K search radius, you really need 8K of cable. Then when you use the 8K radius, aren't you really using more cable? Because you're going further. That's the point, isn't it?
That is absolutely the point.
Yeah.
And so that's why certain areas within the 8K buffer are not developable, because they are more than 8K down the road.
That's the thing that confuses me. Is methodologically, if you've decided to use 8K radius, you should really have decided that, you know, proportionally more cable was used. What you've done is you've said, we'll apply the 5K radius, but then we'll extend it. That will involve 8K cable. We're going to do a larger site radius search, even though that will require even more cable. I just don't understand, because you've then discounted some bits within the 8K radius, but that should have been after the radius size had already been determined, shouldn't it?
No, I'm not quite sure why you've got such a problem with this. It's fairly clear to me that the cable length, maximum cable length is 8K. In some locations, as you pointed out, so if we let's go to that cable length plan, round about 5 o'clock on the boundary of the 8K is Newington.
Hang on. Yes.
Yeah.
Newington.
And the blue line, which is the 8K cable, almost reaches Newington.
Mm-hmm.
So arguably, that's almost the direct line. It's just almost as far as you can get if you had an 8K cable. So that's why that's as good as an 8K radius. And then, so yeah, let's make the search area based on that radius. But there will be certain areas within the search area which clearly are not going to be practicable, because the cable's going to have to be longer because the roads are more wriggly. And that's the reason why an area on the periphery of the 8K that's got longer road routes for it is dismissed.
Great. I think we can see, can't we, on Appendix 1, you see where the site is in respect to the cable itself.
Yeah.
And am I right in thinking the cable stops a little bit short of the site there?
It stops short of the planning application boundary. It reaches the land ownership, which aligns with the study area in the talked about PMV assessment. So that is the land ownership. The constraint within the land ownership is lesser because there is a known parameters in terms of what the land is, how the land works, who, but it's easier and not as arduous or not as expensive to put a cable through the farmer's land that you have a contract with.
Okay, so you don't have to necessarily use the road to cover that additional bit. I don't know, let's call it 500 meters.
Yeah. You run a cable through the agricultural fields, and you know what's there. You know you're not crossing the any kind of leeways or anything like that. So it's straightforward.
Okay.
So that's the boundary of the site in terms of the ownership.
And the limit on the length of cable, I'm going to be quick now because I know we've got to get through this. Not a technical issue, it's more a financial viability issue. So far as the longer the cable, the less efficient you say it is, the less money can be made from using it. Is that a fair way to characterise it?
But also, because you'll be doing it in the public road, there are less, the further you go and the more you have to overcome in terms of dealing with the stats in the road, dealing with big road junctions, all that kind of thing.
Okay, so there's more.
It's just more problematic.
Right, okay, with you. Insofar as it is a viability concern, which is what you say in your proof, haven't provided any justification for that in your proof.
No, covered that in evidence.
No. Yeah. You see Mr. Reynolds refers to the Milton Common farm, runs 13 kilometres, significantly longer cable. Yeah,
I
think you said the sites were very different, but it's a similar size site, isn't it, as far as I understand it?
As I said, in evidence and check, different parameters, different considerations for different sites, and the detail of that.
Okay, right. Let's move on. Cover this one quite quickly. you say 1.10, 1.10, it's another way to say it. BMV is not given a higher status than other designations, right?
Yep.
Local plan directs you to use areas of poorer quality land in preference to that of higher quality. Can't give effect to that in your scoring, can you?
How do you mean? Sorry, say that again.
So if your scoring system doesn't give BMV any sort of status, how can it direct you to use areas of poorer quality land in preference to that of higher quality land?
It's saying it didn't give it higher status and other designations, some of which, however, takes in such as ecology. So it's one of the considerations. It wasn't paramount and it wasn't lesser.
Paramount. Okay. Let's go to the differentiation of grade 3 land at points. We've got in this report, you've ruled out all grade 3 land. Of course, Mr. Field agreed with me. There is a significance of the difference between grade 3A and grade 3B land, isn't there?
Okay.
So bundling them together, you've necessarily excluded land which is not BMV from potential alternatives, haven't you?
Well, that may not be BMV.
What?
Well, the fact is that, as Mr. Peel explained, there are 5 categories, and the BMV within category 3 is lumped together with the non-BMV within category 3, 3A and 3B, and best available information to make the assessment on in a reasonable way is mapping that shows them in the same colour. And so it's not known which bits of that colour are BMV and which are not, and some will be, some won't be.
So you can't say, can you, the development won't be stationed on, or there wasn't available non-BMV land in the connection area?
We haven't said that, no. Because that's not set.
And the reason given for grouping 3A and 3B is that establishing subcategories is costly and time consuming, is that right?
Yes.
And you're aware that that failure caused the inspector in Lullington to consider that the evidence had failed to establish that there was no land available of lesser agricultural quality. You're aware of that?
Yes.
And will you agree with me that that is a similar, if not identical, issue to the issue that I've just explained?
I don't know, because in Lullington, I don't know to what degree that was questioned and challenged. I don't think that it would be reasonable for us to have to go and undertake detailed assessment of third-party land over which we have no control and over which we potentially would not even have a connection to a grid to deliver.
Mm-hmm.
And if we did, in all likelihood, that connection to the grid would be sometime in the late 2030s.
Would it have been possible to conduct a sample survey? Wouldn't have to have surveyed it in detail, would you? Go through land?
I understand you probably would have to survey it in detail. It's not a simple approach. You can't just go. Mr. Field would have been a better person to direct these questions to, but my understanding of it is that Mr. Field can just turn up and have a look and go, I think it probably.
Mr. Field described at length actually the process that I said that you'd have to go to. I'm asking you whether you could do a sample survey, not a full survey. Don't have to sample a particular site in detail, could sample, choose, I don't know, half of the land, survey half of it. A sample.
Well,
I'm only asking you this question because that's exactly the approach that the High Court accepted in Lullington, paragraph 36.
Right. Well, it's a sample survey would not be a reasonable approach either, in my view.
There's been questions about how to survey the land to detect the grade were really for Mr. Field, who was here to answer.
I'm asking about whether it could have been done. I'm not asking how it would be done. There's another solar development in which the possibility of sample surveying has been accepted by the High Court as being a viable way to distinguish between grade 3A and 3B land, isn't there?
If that's the one you're referring to, is the one.
Yeah, but yeah,
My view is to go out and assess an auger, third-party landowner, which you have no control, not a reasonable approach, but that's what your policy seeks is reasonable.
I accept that's your analysis. That's fine. You haven't approached any landowners for that process, have you? Because you say it's not reasonable. No. And you say, I'm just going to move on from this particular. We've got this additional versus alternatives point, right? You say this document generates alternatives and they all should come forward. Yes?
Essentially, if they can get connection.
I've got to give you the chance to comment on this because I'm going to say something about it in my closing, but the local plan policy requires you to generate alternatives to consider, doesn't it? Des 7.
We've gone through it and what Des 7 says.
Yeah.
Yeah. It's.
No, I hope not.
No.
I know you say that it doesn't mean generate alternative sites. If it does, if I'm right about that analysis, then this document wouldn't be doing the thing that Des 7 requires it to do, would it? Because it's generating additional sites, not alternatives. Right, let's whiz through this dismissed grade 4 sites. I know we've been here a bit longer than I thought. In part a function of us disagreeing slightly more extensively than I'd hoped we could, but I'm sure that's my fault.
Apologise for that.
No.
It's nice to
disagree
with you.
Maybe next time. Right, we've got these grade 4 sites. Let's go through them. They're all sites which are lower quality land in agricultural terms than the present site in Ireland BMV.
Yeah.
This is the refined site selection reports. They're not ones that were generated in the previous report.
Sorry, which report?
This one. When I'm talking about the reports, I'm talking about the CSR.
Right. Okay.
I hope.
Yeah. Okay, that's fine. So you're looking at the sites that we said, the 1 to 10.
Well, I don't think they start at 1. I think they start at 4 for
The
real
locations,
yeah.
right, yeah.
So let's do area 5. Start with area 5. Probably helpful for this bit just to have Mr. Reynolds' analysis in front of you. And Mr. Reynolds' analysis is sorry. Not Reynolds,
It's proof, isn't it?
yeah, it's in his proof.
But he does his critique of results.
Yeah, that's it.
34.
Yeah, thank you. Okay, probably helpful to have that in front of you. I think the point you make in the report, or the report for now, area 5, and this is page 18 of the report, goes on to 19, that any land would be developed would be too small to accommodate a development proposal. See that?
Yep.
Mr. Reynolds then points out that in reality, you look at area 5 and you turn up figure 5 on his proof, page 35.
Yep.
An area of 60 hectares north of Oxford Road, where the proposal could be accommodated. That's what he said.
Yes.
Your report said the parcel of land in question would need offsets, rights of way, respective dwellings, and that would result in the land being too small. He points out, you can see the thing, figure 5, plan figure 5, he points out there are bits of the field close to the residential properties which have not been taken into account. There's a sort of buffer there in the 60 hectare parcel. Do you see that?
Yep.
You don't take any point on that buffer or any point on size of area in your rebuttal, as I understand it. Don't take that point any further.
Not in the rebuttal. What we've said in the rebuttal is about topography and the capacity to develop all of that site. And so we are criticising the size. I don't agree with Mr. Reynolds' assessment of that land, which I think he's estimated at 60 hectares and 59.9. Can't get it all forward.
Right, okay.
And so the reasons behind that are topography in the north. I think he accepted would cut back if it's too steep, and that's shown by those contours on the plan in our rebuttal, also on that plan, and also which you can see in our figure 12 are the footpaths that bisect the site and also are immediately along the northwest boundary. So lots of footpaths, lots of visibility of the site.
I don't want to be a pain.
I know we're going to be a long time.
I know what your evidence is about these. They're in your proof. If you think I'm being unfair at any point, please stop me. I just want to ask you the questions
Right.
that I want to ask you.
But I think
If you want to, I mean, look, the inspector can read it for what the rebuttal and the proof for what your case is as to why it can't come forward. I'm asking you different questions.
okay, go.
So your rebuttal says the council unreasonably considered this site to have been ruled out on size alone. Remember that?
Yeah.
Now, on the basis of the text in your report, Area 5, that is the predominant criteria by which the site is ruled out, isn't it? Size. Not asking you about the rebuttal.
Yes. Yeah, the land.
It's just
So you're referring to 4.27.
yeah. I haven't even said it's the only criteria. I just said it's the predominant criteria, right?
Predominant criteria.
Yeah. Your concern there is predominantly about size. And now it's the first time in your rebuttal that you introduce these other key considerations. Yes? Don't mention them in the proof.
That's correct. But they are considerations that are highlighted in the report in terms of the constraints, and by reference to
Well, they're not in the report, are they? Let's be clear.
the
The
constraint.
topographical point, it's not in there.
The topographical point isn't, but that's in the rebuttal. The other points, the other constraints, are highlighted on the constraints plan. In terms of the heritage, the footpaths, the adjacent country park, proximity to residential properties, are all constraints that were taken into account in the report. And yes, the text just says size. That's because as a consequence of those constraints, size isn't achievable.
And you say it's a steep gradient in the text.
Yeah.
Just asking you about the text in your rebuttal doesn't say what it is, does it?
I haven't given the actual gradient, no.
Don't analyse what kinds of gradient are and are not acceptable,
No.
or why. And the contour lands, the contour lines, I had to look this up. I was going to call my cigars. That's wrong. Contour lines that we're looking at are in the top left-hand corner of the site, yeah? In the centre of the figure 2 to your rebuttal. Figure 12, rather.
Yeah. So, yeah, they're the brown lines with the numbers on them. 85, 90, 95, 100, 110, going up.
It's a relatively limited parcel of the site, isn't it?
What is?
That dimension of it, where the contour lines are, the bit where it's steep.
No, I would say it's by rough approximation a third.
Right. Good.
And the implication of that isn't just that you can't build on it, It's by virtue of the footpaths and the elevated position, then there's visual impact as well.
Area 6. I think you say there's no cable route which goes there, no local road under which such a cable could be sited.
Yeah.
Inspectors heard our discussion of longer cables, heard from you about how cables don't always have to go under the road. There's the potential for overhead cables. Mr. Reynolds, I'm not going to cover that. We're going to have to go back to that 8K roadmap, which is Appendix 1 to the report.
Sorry, I don't.
I don't know if you can make it out. The areas map is at Appendix 5. It's probably helpful having both out at the same time.
Yeah.
Right. See that? Do you see? Can you pick up and orientate yourself from the, for instance, Holton on both maps? You see that?
Is that so Holton is
Just outside the 5K
to the
radius.
south of the 6. Yeah.
Yeah. Okay. Right. Holton Wood, the road stops.
Yeah.
You see Forest Hill just on the blue splodge.
Yeah.
So the missing connection is about 1 kilometre. Is that right?
Sorry, the missing connection from where to where?
The missing bit between Area 6 and the edge of the cable. Okay. You said that's about 1 kilometre.
Yeah.
And there's a road, isn't there, to the right? You see that sort of arcs back towards Area 6, goes away for a bit. I don't know what it's called, that road, but you see it?
Is that the motorway?
Yeah.
Yeah.
So it goes away.
Directly between Holton and Waterbury.
Yeah, that's right. Do you accept that's a kind of road under which a cable like this could be buried?
Don't know the detail. It looks like a significant road in the highway network. I'm not an electrical or a highway engineer.
Okay.
It looks as though it's significantly outside the 8K blue line to me.
Okay. But it's about a K left in terms of, as the crow flies, right? About a kilometre away. All right.
From Holton.
Yeah.
Yeah. Outside that, I'd further K. But it's how you get there.
Yeah.
That's the question. You have to go all the way down to the junction, as we've seen.
Well, there might be circumstances in respect of land ownership where there's a part of land that you would be allowed to utilise in the same way as in respect of the site you've actually selected. But that's not a consideration that features at all in this assessment, is it?
It's the whole area to that north east, if you say sector, so you've got a sector that goes from effectively 12 o'clock to 3 o'clock around beyond between the 5K and the 8K. There's a whole sector there that none of the area is accessible by a road network that is less than 8K.
Okay, well, let's do Area 7 because we've got to go through this now. I think the point is that there is some subdivision here, flood zones near listed buildings. Mr. Reynolds has got this 92 hectare area within his figure 6. Just turn it up so we can look at it. So it's not an area impeded by the road or the Thames, not in the flood zone. And I think what you say in the rebuttal is that the problem actually is with the grading of the land. It's the same issue that you raised in respect of Area 5. That's not something that you mentioned in the report, is it?
It isn't raised in the report. I think let me see what It's area 7, that's 431. But again, I've just referenced you without going on again about different things, but figure 13 shows all of the constraints. It's constrained by footpaths, it's constrained by proximity to heritage assets alike. It's more constrained than our site, in addition to the fact that, as I pointed out in the results, topography is unsuitable. It faces north. It's too steep. The majority of it, you wouldn't get half of what Mr. Reynolds has suggested, and it's bisected backwards. So it's a lesser quality site than our site.
Okay. Grade 8, or area 8 rather. Grade 8. Grades on the line. Area 8. This is a site where, or an area rather, there actually has been a solar farm application which has gone in.
Right.
Previously, you said it was unsuitable in all the reports which preceded this one. Is that right?
Yep.
Not much of an endorsement of the previous reports, is it? Ruled out this site.
It was
Turns out
ruled out
actually
on
it's-
availability as well, and it was one that was assessed. You know, it's clearly come forward, presumably because there was already, we talked about the time it takes to bring sites forward, but then that they're already in negotiation with somebody else.
and it's a 49.9 megawatt application going in, same as this one.
Yeah.
Okay. Again, previously unavailable, now it's available. I understand the Pegasus Group is the agent.
Yes.
Yeah. So you ruled it out as an applicable site or available site in October 2023, and then brought it forward as an additional site for your use, or use of one of your clients. Is that right?
Yeah.
And it doesn't look great, does it?
It wasn't available for this proposal at that time.
And I understand from Mr. Reynolds' proof that it was the soil testing changed the day. Is that right? Or am I wrong about that?
I'm not sure, to be honest.
Okay. Let's move on to 9. The report says there
Just
are.
on 8, whilst we're still there.
Well, we weren't.
But other than that site, which clearly isn't available, there aren't other areas in 8.
Yeah, well, I didn't ask you about those.
Okay, I'm just making a point.
Area 9 says there are areas of woodland which make development unsuitable. That's what the report says. Mr. Reynolds, figure 8. He's got a parcel of land of 227 hectares in area 9.
Yep.
Which is grade 4 land. Can you see that?
Yes.
Can't see any woodland there, can you?
I would acknowledge that what's been taken as woodland is that green, that darker patch. I think Mr. Reynolds is correct. That is not woodland, so that's not. That is not a correct point in this report. However, as we can see from figure 15, the area is crisscrossed with footpaths. There's the conservation area of listed buildings. It's got much more constraints than our application site. In addition, the area to the within 9 to the western part falls where the Nineveh Farm planning permission is. There's also an area to the north of Nineveh Farm, which is within the allocation, the strategic allocation. So actually, it's not correct to say all of area 9 is available. And better, it's not better.
You wouldn't need all of this 227 hectare parcel of land to bring forward your development, would you?
You wouldn't, but as I say, I think it's more constrained. So
No analysis of, I mean, what the report says is that the area to the north of Two Falls is close to the conservation area, and there are some listed buildings, meaning it's likely to be unable to accommodate solar farms. No analysis there as to how the fields contribute to this. The heritage assets, is there?
not any detailed analysis. I think it's professional judgment. It's a reasonable and proportionate approach that needs to be taken. I think to do individual heritage assessments of individual assets when you're doing a high level site assessment is not a reasonable proportionate approach.
Is there any problem with the gradient of this site, or is this one all right?
I haven't applied to the gradient on this one.
Okay. Area 10?
Yeah.
Is the best one. 2 areas which will accommodate the development, you say?
Yeah.
So the south, you say there are large fields that may be suitable. Okay, there's a farm building there.
Yeah.
Firstly, could demolish the farm building and build, couldn't you? So madam, you can apply for planning permission for.
It would be a particularly sustainable approach to farming. If it's a working, usable farm,
Does it say that it's a working, usable farm?
I don't know. Right?
Doesn't.
I don't think that's a reasonable proportionate approach either.
Existing farm complex. Doesn't say anything about what it is. Right, okay. We're talking about the one to the site. So the site, the south, sorry, we've got the south, site to the south. Farm, the area itself is 95 hectares, that particular parcel of land to the south. So you wouldn't be required to use all of that area, would you? For your development.
The area to the south. No. My note on the area to the south is that falls within the same ownership as number 29, which is site. So within the PPS site collection statement, after paragraph 451, there's a table of the sites that were approached.
Well, is this all supposed to be superseded? This document's supposed to be the document that one looks to for the answer. Has it been superseded or hasn't it, or do we read them all together? If we read them all together, then we should be comparing them and analysing them for differences. I've taken this at face value that this is supposed to be the one,
Okay,
the one that
well,
matters.
It's the okay. Well, I'll tell you without referring to the evidence that people were approached and the site isn't available.
Right. Okay. So that's the one on the south.
It's area 29.
Identified 2 parcels of land. We've got the one to the south you say couldn't be used. The report says nothing about the parcel to the north, does it?
No, it doesn't.
No analysis whatsoever.
That's correct.
So far as we're concerned, this is a non-BMV parcel of land identified within an 8K radius within area 10, which has not been discounted by your report. Right?
Okay. It's also, if you look at it in terms of the constraints map, it's affected by the constraints that we've acknowledged. So there are just the buildings, there are crystals in the sides, it's close to the village, so it's more constrained than outside.
I mean, you can add that explanation now if you want, but your report doesn't say anything like that, does it?
I can't, I'm giving evidence now.
Okay. It wasn't in your written case.
Yeah.
Was it?
It wasn't. But it was incorporated into the report in terms of the constraints that are shown on the constraints plan as an appendix of a submitted report for the option.
We produced a rebuttal on 2 of these areas, coming back to Mr. Reynolds. And you obviously didn't feel like that omission needed anything. That's why I'm criticising you for not covering it. It's not unfair.
I think the purpose of the rebuttal is to provide information that's not currently before the inquiry. All of the information in terms of the constraints on footpaths, listed buildings and the like were included on the constraint plan that were already before the inquiry. They're reasonable evidence that I think I can refer to independently.
Well, I'm not saying you can't refer to it. I'm just saying that it's an omission from the text of the report, isn't it? You've been at pains to explain why all these other areas aren't available. We've got a subdivision of area 10. You haven't explained why it's unavailable. You now are. That's the only point I'm making.
Okay, so the point, but it doesn't negate the fact that there are constraints that make this a lesser suitability site than the application site.
If you could turn up CD5, we've done the areas now, and we're on the final bit.
Nearly there.
Thankfully, I'm quite keen on lunch as well, but we'll get there. Area 10.5. Area 10.5? CD 10.5. B. It's an appeal decision. It's not actually. It's a approval. Land west of Cowley Way. It's another solar development.
What
CD 10.5.
temple?
And so
It's probably. It looks like it's under CD1. You see, because it's that 10 comes under 1,
right,
42.
yeah, thank you.
Yeah.
which part of 10.5? There's 3 different
I
documents.
think it's probably. We can take it up.
Southwest of Cowley, is it?
Yeah. The report is probably the bit we
B.
want to go to. B, yeah.
Delegated.
10.1B. 10.5B rather.
Oh, the committee report.
Yeah.
Abstention.
Are you familiar with this particular application? Do you know anything about it?
Not in any great detail.
When I try and open that up, it's saying there's a problem.
It's not opening for me either. It's really annoying.
There are 2 versions of it, but one should be openable and the other one.
Okay. Well, will you? Perhaps we could just deal with it as a matter of principle.
It's open for me.
Oh, okay, fine. I'll have to do it from my note. I don't have it in front of me.
I can read it out to you.
Okay. So that site's crossed by 2 public rights of way. See that in the
Whereabouts is that? You don't know.
6.29 my note says.
Right.
Yeah.
Yes, there's a plan at 1.5 to show two public rights.
Okay. It also shows the topography.
It does.
There are some topographical issues there. Put it like that. Yeah.
Well, what it shows in topography is that there's undulations. It's by no means as steep as the ones that I pointed out in the other areas.
Okay. But we have, don't we? We have these rights of way crossing the site. It's got, I mean, the purposes of agreement can say it's imperfect topographically for the siting of a solar farm.
Yeah.
Okay. And it's in the setting of a number of heritage assets. No. And my point is that it's not the case that topography, heritage, or public rights of way are knockout blows with respect to building a solar farm, are they?
No, but what we're looking at here is the relative merits of sites in respect of the range of different constraints. And so just because this planning application has been granted with constraints doesn't mean, another site that hasn't got constraints shouldn't come forward. Fact is, if you look at our site, it's actually better than this one. It's not crisscrossed. Hang on, just let me finish. But it's not crisscrossed by footpaths. It's not got those topographical. And the point I've been making is not comparing with this site and our site. It's comparing our site with the 10 areas that are identified in the site selection, and using those criteria, our site's better than those 10 sites.
I'm not going as far as that. That's not what I'm suggesting. All I'm saying is that there's no technical reason why public right of way, for example, is incapable with the solar development. That's not what you're saying.
That's not what I'm saying.
Okay. There's no reason why heritage issues may, and depending on the balance in particular, but there's no reason why those necessarily are incompatible with solar development.
Yeah.
And the same point to a certain extent on topography. Right. That's as far as I take it. That's all I'm saying. Do you accept that's a fair summary?
I accept that as a fair summary. I would add that in the context of looking at the merits of different sites, then the merits of our site in respect of the other 10 areas, we are less constrained.
Okay. Done. On harms benefits, it's 3 question areas, then we're out. There's going to be an interruption of the use of B&V land, isn't there? It's not being used in the same way it is now.
It's not.
And we know there's going to be some loss of B&V land for the 40-year period. We know that, don't we?
Yeah.
Now, my question is, in light of those 2 concessions, is it really fair to give no weight at all, neutral weight, to the approach to B&V land this time? You've just agreed with me that there's going to be some loss, albeit a relatively small one. We've agreed with Mr. Field, I don't think you and I have quite agreed it, but with Mr. Field, that B&V land is valuable in the planning system. We know some of it's being lost, albeit, as you say, a relatively small parcel. We know some of the rest of it is being interfered with, not being capable of being used in the same way. In that context, what I say, and the question I ask you, is it entirely fair to afford neutral weight to the way in which B&B is being used in the course of this development?
Yes, and the reason for that is that you've just highlighted the impacts that there are benefits as well, and that was what Mr. Field was talking about yesterday in terms of the benefit of resting the land, the carbon benefits, the quality of the soil benefit. So those benefits balance those effects.
Well, they would in your planning balance,
No,
wouldn't they?
in terms of the impact on the land, they do as well.
Okay. Let's get to this. Right, okay, yeah. If I'm right about my construction of DES 7, there's going to be a further conflict with the development plan. Would you accept that?
Further than what?
You haven't identified a conflict with the development plan. That will be an extra harm that hasn't been taken into account in your balance. If I'm right about DES 7.
Mr. Reynolds accepted it's 1 harm to B&B and DES 7. I asked him that specifically after your examination sheet and he said it's 1 harm.
To B&B and DES 7?
And DES 7, it's 1
Okay.
harm.
Okay. In which case we've got a harm, if that's the case, that has not been taken into account in your planning balance at present.
If you're correct in terms of the policy, lack of policy compliance, it's not in my balance because it's not a harm, because there isn't a lack of policy compliance.
Okay. And then just on the B&G moderate weight point, remember that one? I've got some cases in which inspectors have applied moderate weight to B&G despite there being 1,000% all of that. Is it necessary for us to go through them, for us to establish the principle that B&G, or the weight that one attributes to B&G, is a matter for an individual inspector?
No, that's fine, I agree. It is for the inspector to determine. I've just put my point, I think.
Are you able to give the references?
Yeah. DD 7.43, paragraph 61.
Mhm.
CD 7.47, paragraph 50. CD 7.50, paragraph 31.
Mhm.
CD 7.57, paragraph 47.
Thank you very much.
So, short point, inspector can agree with those inspectors or B&G moderate
Yes.
weight. And insofar as Mr. Reynolds was doing no more than applying an approach that had been applied by those inspectors, that was an entirely reasonable approach.
That was Mr. Reynolds' professional view.
Yeah. And all I'm saying is that's an entirely reasonable
I
approach.
would suggest it's been unreasonable.
Okay, great. So, thank you so much. Thank you. I'm
Thank you.
so sorry I went on longer. than I timetabled. I'm sure it's partly a function of my questioning.
Right. And I've just got a couple of quick, they're just kind of clarification points really. One which was slightly picked up by Mr. Clark. Just because paragraph 1.46, and just had the 3.18 or 3.19. In paragraph 1.6, it says this supersedes and should be read in place of the previous one.
Yes.
And then in paragraph 2.1, it says that the previous one produced by Pegasus remains largely up to date and should be read in conjunction with this addendum. And paragraph 5.5 also refers, says this update and previous site selection step to provide explanation about choice of site. So I'm just trying to understand whether the previous ones are superseded by this or not.
I think they're information that's fed into the drafting of this report, so I think they are relevant to the considerations in this application.
And just in paragraph 3.7 of the same thing, and again it says the third sentence, digging along such routes would inevitably encounter constraints. I think you talk about in the urban area of Oxford. I was just trying to why is digging up roads in the urban area different to digging up roads in the rural area?
It's both the constraints. I don't think that necessarily, but just because it is in the urban area, then there's going to be more disruption just because of the activity and busyness.
Right. So yeah. So it's more. It's more disruption.
It's more disrupted because
more people around. Yeah. No, that's everything. Everything else has been asked, so that's all right. So
I'm going to try to keep it as short as possible and I can address most of the points I think in closings. So just give me a few seconds to look through to see what I can cut out. Okay, there are a few questions. There's not very many. So the first one, if you could just take up the Bramley High Court decision that you were taken to. It's called document 7.11. It is about 5 areas in question, so there's not a huge amount, and I'll try to be as quick as I can.
Yeah.
So you were taken to paragraph 169 and paragraph 57 within that.
Yes.
And do you remember a line of questioning where you were asked, it was basically put to you that Bramley is an entirely different context because there's no requirement to consider alternatives. But here there is a requirement to consider alternatives. And what you said is here the local plan doesn't ask you to look at alternative sites. It looks for you to consider alternative options.
Yeah.
So can you just see what Bramley actually says there? What's the last line of paragraph 57?
Accordingly, I do not consider that planning permission should be withheld on the basis of a lack of identified alternative sites being considered.
And if you look up again the second sentence, I was not directed.
It's not, yeah.
So is it about alternative? Is it about alternative sites there or alternative options?
It's sites.
So is there a comparable policy context?
No.
Well, if you're saying that if there's no alternative, no requirement to look at alternative sites there and no requirement to look at alternative sites here, is there a
that's
comparable?
comparable, yeah. Fine.
The next one, I'll just, if we can quickly take up the PPG, you were asked core document 6.2.
Yeah.
I think you were asked some questions about whether the local plan, like the PPG, asks you to show that use of BMB is necessary. Do you remember that? Well, you might not. It was a long time ago.
Long time ago.
Yeah, no, we did do that.
If we go to the paragraph 13 there, within that, I just want to see where the word necessary comes in.
Yes.
So if you see the second bullet there,
yeah,
where a proposal involves greenfield land and whether the proposed use of any agricultural land has been shown to be necessary. So is any agricultural land the same as BMB land?
No, it's not. It's any land at all.
And does the council here suggest that non-agricultural land would be available for the solar farm? Does it suggest there's PDL sites or brownfield sites?
No, they're not.
So has use of agricultural land been shown to be necessary in the present case? Next, we're on the site selection.
Slow down a bit.
Sorry.
I made my notes picking up.
Yeah, okay, sorry. I'll take a break.
Right, yeah.
So the next one was the site selection report. So that's core document 3.18. So just a few questions on this. So the first set of questions were saying, well, you don't say there's a sequential test in policy, but you've done a sequential test anyway, and you were taken to paragraph 4.1, and I think the suggestion was that somehow implicitly you've accepted that a sequential test was required. Do you remember that set of questions?
Yes.
Well, I just want to look in this report where it explains why a sequential approach has been adopted. And so if you go up to paragraph 2.9.
Yeah.
Can you just read that paragraph, please, and explain why a sequential approach was adopted in this report?
Yeah. It's in the final paragraph, so the final sentence. So it's making the point in 2.9, there isn't a test, it's referencing Bramley, then states the lack of sequentially preferable sites may, however, be a benefit to be weighed in the planning balance. And again, so no harm arising from loss of best and most goods.
So how does this site selection report end up featuring in your planning balance? What's its relevance to your consideration?
The relevance is the weight that I've given to the lack of available sites.
As a benefit.
As a benefit, yeah.
And you were also asked in terms of the sort of this policy section, you're asked if the site selection report refers to compelling evidence and talked about the written ministerial statement in that context. And I think you answered this in chief already, but just to confirm, in your view, does the compelling evidence test mandate any consideration of alternatives?
No.
You were asked about Lullington and the appeal decisions at the end of Mr. Reynolds' proof.
Mm-hmm.
I think one of those was dated from 2015,
Yes.
the last one. Are you aware of how many appeal decisions in the core documents have been allowed on BNVAO? You may not be, but
I haven't got figures to hand. I know a considerable proportion of them have.
and are you aware of any appeal decisions other than the ones Mr. Reynolds has found where there was a dismissal on BNV?
No.
And are you aware of appeal decisions other than ones that have gone in here where there's been approval of a solar farm?
Approval of a solar farm in DNB.
Yeah. If you're not aware, then you can show me the answer. That's fine. Thank you. So the you were also asked on this site selection report, two other methodology type questions. You were asked, it was put to you that BMV had not been given a higher status than other designations like ecologically sensitive sites or AOMB, or even BSC for Greenbelt. In your view, how does the policy test for BMV compare in strength to those other designations like exceptional circumstances for the AOMB?
I think it's a lower test for BMV. I think there are requirements in terms of heritage assets and Greenbelt, BSC, AOMB are all very high level constraints and policy requirements.
So in some way, this report has given more status to BMV even than you consider necessary.
Yes.
And the final question on this report is, I think a point the council's trying to make here is that there's a sentence in this report that says, if we find any alternative sites, they're additional sites, they're not true alternatives. And I think the point that council wants to make is that that means you can dismiss this entire report as a consideration of alternatives, because that's not what it was setting out to do. But in practice, the approach it's gone through, sequential approach, looking at different areas, I mean, would that be any different if you were looking for, if you didn't think that an additional site wasn't also required, or is it a similar approach of looking at different areas and looking at their constraints?
It would be a similar approach.
So if the council's right, you need to look at alternatives. Have you looked in that report at alternatives?
Yes.
So the final set of questions I want to ask you about relates to the Lullington High Court case. And do you remember these questions about if you sample one bit of the site, that might be okay? So this might be a matter for legal submissions, but if you just take up Mr. Field's proof, you have that. No, I've just realised there's one other set of questions after this. I'm sorry, I thought there's
Yes.
do you have you go in there to paragraph 2.1.
Yeah.
So can you see that sets out the guidelines for how you do soil site sampling?
Yes.
You have to use the MAP guidelines and the Natural England technical information note, and I think Mr. Field explained about the number of borings and all of that.
Yeah.
Are those MAP guidelines or the Natural England technical information note mentioned in the Lullington High Court judgment, as far as you're aware? If you're not aware, that's fine, but I mean, it's not mentioned in there.
Okay.
It's a matter of fact. We can agree it, and we can make submissions about that. So I promise this is the final question now. Just wait for the inspector a moment.
Yeah, no, all right. I'm watching.
So I just want to ask you briefly about paragraph 187A of the MPPF, because this wasn't a point that Mr. Reynolds raised in his evidence. It was a new point taken today. And that's about protecting and enhancing soils per their statutory status or identified quality in the development plan. And I just want to think about the difference between soils that are protected for a particular quality and best and most versatile agricultural land. Because obviously we've got a definition of BMVAL in the MPPF itself,
Yes.
so don't we? And we've got CD 6.31, which is those MAP guidelines I was just talking about. And there's a introductory section there that explains what BMVAL classification involves. And are you aware that it's partly soils, but there's a whole range of considerations, including climate and a number of other factors that go into the BMVAL grading. Yes. And because you could have a policy in the local plan that, for example, identifies peatland or a particular type of soil for special protection.
Yes.
Do we have a policy like that in this local plan?
No, we don't.
And I think you said this already, but in your view overall, does this development protect the soil resource on the site?
Yes, it protects it and indeed it enhances.
Those are all my questions. Thank you very much, Mr. Wilson.
You may stand down, Mr. Custom. I'm just trying to relax. We're all clean. Oh no. Oh no. Right. So it's 2:15. I think the earliest we can meet on site is probably kind of 3:15.
Yeah.
I mean, if not 3:30, probably, to give people time to eat lunch without having to stuff it down and get indigestion and get out to the site. I think probably 3:30 is probably more realistic than 2:15. So I'm sorry for Mr. Cook's.
Oh no, he'll.
I've just messaged him.
Hanging around.
Don't worry about it.
Oh no,
Don't worry about it.
So yeah. So if we meet at 3:30 at the actual farmstead, then who's coming?
Just Mr. Cook.
Just Mr. Cook from your side.
Just myself.
Right. And that will see you then.
And do you want to start tomorrow morning at 9:30?
Do you want a bit longer? I mean,
I'm not going to write it in the morning.
Yeah.
You'll be doing it. Yeah, doing it now. So
quite a chance to get up early and hope you've got enough time.
different people work in different ways. Some people will work better at 5:30 in the morning than they are at 11 o'clock at night.
Absolutely terrifying.
Well, I'm better at 5:30 in the morning than 11 o'clock at night. Yeah, yes, I know. I'm not a night owl. I'm a lark. So I mean, are you
happy with 9:30 just to know what time?
Yeah, I mean, I'm happy with 9:30 as long as that works with everyone else. So, well, I'll see you at, everyone else at 9:30 tomorrow. And you. Thank you very much.